Good morning. We made it to Friday. Pat yourselves on the back. We made it through another week. I am Alternate Jer. Thank you for joining me this morning. Quick shout out to Justice as a Process. If you've not checked out his channel, you need to. He's got a lot of good information on there. And he shared my video the interview that I did with Lauren and uh, Ty. So thank you very much for doing that. And like I said, check out his channel. He's got a lot of stuff on there. He did a pretty deep dive into uh, Ty and especially what Ty's daily life is like. I talked to you guys about it a little while ago, but that is where I got all the information from. So good morning, Gabby. Glad you did not get ran off the road, and darn it, we didn't get to hear what you had to say. Or read it. We only get to read it. We never do get to hear it. Good morning, Chrissy. I wrote down Rebecca Grossman. Not familiar with her, so I will have to check that out. I hadn't checked, so I saw that I had picked up a couple overnight, but yep, that's pretty exciting. So I am pushing towards 1,000. And so thank everybody for being here and subscribing because honestly, when I if I say I can't do this without you guys, it is the absolute truth. I cannot. Oh, me too. I have yelled at people in my car. They're in their car. We're driving. We're not together, but they can hear me, right? Or I just talk to them. I generally, if I'm driving, I just call out the kind of car that's in front of me that's doing something stupid. Like, "Oh, good job, blue Toyota." That's me. And I actually had one of Carmen's friends doing that for a while because that's just the way I do it. It's the car's fault. All right, we are going to get back into this. I don't have any updates for you guys. Otherwise, I'd give you some, but I got nothing. So we're going to go back into this Haley Brown trial and finish it up. And I can see that the attorney whose mother passed away during the day that we were watching on Wednesday is back. I would not have been, but kudos to him, I guess, for finishing this up. That would have been difficult for me. So if you haven't been watching, this is Haley Brown. She's on trial in Tennessee. She is in what's his name? Judge Wolf's courtroom. She was 28 years old at the time of this accident happened. She is accused of drinking and driving and running into a utility pole, which caused the death of her fiance. So she's charged with 2 counts of vehicular, I think I could say homicide, one with recklessness and one with intoxication, plus DUI. So we have seen all kinds of, she is a screamer. And not in a good way. Yes, the poor woman. And we are all very torn because we all can accept the fact that she was drinking and driving and she should not have been. Her blood alcohol level was 0.16 2 hours after when they did the blood draw, 2 hours after the accident at the hospital. His was 0.25. So neither one of them should have been behind the wheel. And she's just a person that made a really, really bad decision. It's going to affect her for the rest of her life, whether or not she gets convicted here today. So not excusing her, not saying that she should not be convicted. I am not saying anything like that. I'm just saying I don't know what else to me, they can't really do anything else to her. She's probably destroyed as a human at this point. This happened in 2020. I don't know why it took 4 years to get here. Once we get the verdict, I will look for that. But um, this happened the week of, well, you can see. So March 6th, 7th, and 8th. And so I'm gone to look because I want to see the verdict with you guys. But once we do that, then I'll go look to see if there's anything that tells us why this took 4 years to bring to trial. So this is the beginning of day 3, final day. We will finish it up, I believe. I went and did timestamps like I normally do yesterday. And if she was found guilty, I don't have any idea because it came in at the very, very end of the stream. So if she was found guilty, I don't know about a sentencing date or anything like that. And if she was found innocent, then it doesn't matter. I would say they found her guilty of something, would be my guess. But that is only a guess. Alrighty. Yep. Turn that up or you guys won't be able to hear. Make sure you let me know how the sound is.
Good morning, ladies and gentlemen. We are here for day 3, and I believe the state rested yesterday afternoon. So at this point, the defendant has the opportunity, if they choose, to present any proof. Mr. Spratt, do you wish to call any witnesses?
I do, Your Honor. Defense would call Melinda Sue Connor.
All right. Once I start speaking again, I will move the closed captioning. Judge is like, God, quicker than that. Dang it.
Right up here, ma'am.
I
can't grab them. I can't grab them.
We're not going to ask you to raise your right hand to be placed under oath because of the fact that you're in a sling, but just do the best you can.
Oh.
You solemnly swear affirm testimony you give in this case to be the truth, the whole truth, nothing but the truth, so help you God.
Good morning.
Good morning.
Could you state your name for the court?
Melinda Sue Connor.
Okay. And could you go ahead and spell that for the court reporter?
Are we good on sound?
Melinda Sue Sue Connor Conner.
All right. And Miss Connor, do you know or did you know Jason Brown?
Yes, sir.
Okay.
Okay.
Thank
And
you.
how did you know Jason Brown?
Our families were close. His mom and I worked together, and we're both pregnant at the same time.
Uh-huh. Okay. And so were you around him for his whole life?
Yes, sir.
Okay. All right. And did you ever care for him when he was young, things like that?
Yes, sir.
Okay. Change his diapers?
Yes, sir.
Okay. Now, do you know Miss Haley Brown?
Just started, Stormy.
Okay. How
Haven't
did
missed
you
anything. Good morning.
meet Miss Haley?
He brought her to me to introduce her because it was important for him that I knew.
Yes.
He had a good lady in his life.
Okay. And so how long, do you recall the night of the accident?
Yes, sir.
And where do you work?
House of Bruce.
House of Brews
Yes,
there in
sir.
Dixon?
Yes, sir.
Okay. And so if you will, just let me know or let the jury know what was going on at the House of Brews on October 3rd, just in generally what was happening there.
We were doing our annual October Street Fest,
Mm-hmm.
where we serve genuine food and beer, and we have a live band stand, and several bands that play that night.
Okay. And were you working this night?
Yes, sir.
Okay, so what was your role as far as what were you doing there?
I was outside doing hot dogs and brats, being kitchen manager. I also was back and forth upstairs and downstairs.
Ma'am, I'm gonna ask you, if you will reach up there and grab the base of that microphone and pull it towards you just a little bit, it'll slide. There you go. Thank you.
Sorry, sir.
Judge. I was about to ask you to do that myself.
Hey, Felicia, good
Okay.
morning.
So you were working and
Thank you for joining
were you
us.
serving some beers?
No, sir.
Okay.
I was serving the food.
You were serving the food?
Yes, sir.
Okay. Did you see, the best you can, tell me about what time, the first time, did you see Jason and Haley there together?
Yes, sir.
Okay. Round about what time was the first time you saw them?
Between 4:30 and 5 o'clock.
Okay. Now, is that down close to Xander's Pizza?
1 block away. Yes, sir.
Okay. So what direction were they approaching from?
They would have been coming from the north, heading south down Main Street.
Okay, so would that be from Xander's down towards the House of Brews?
Yes, sir.
Okay. All right. And did you interact with them
Yes, sir.
at around, what was that, 4:15, 4:30, so?
4:30, 5 o'clock, something like that. Yes, sir.
Okay. How did they present themselves?
They were happy to see me.
Mhm.
And they wanted to give me love and let me know that they were there.
Okay. And were there a lot of people there that night?
Yes, sir.
Okay. Were there a lot of people drinking?
Oh, yes, sir.
Darn.
I'm sorry about clearing my throat. I've got a bug. Did you see them multiple times
Yes, sir.
throughout the evening?
Yes, sir.
Okay. Did you have a chance to observe Mr. Brown throughout the night, his behavior?
Yes, sir.
Okay. And what can you tell me about that?
He was getting very intoxicated.
Okay. And when you say he was very intoxicated, how many intoxicated people have you seen in your life?
Many.
Okay. Okay. All right. And do you drink?
No, sir.
Okay. Occasionally?
Well, once a year, I might have a glass of wine or a half a beer with my daughter wherever she's stationed, and I go visit.
Okay. She's stationed. Is she military?
Yes, sir. She's Army.
Okay. Have you ever been convicted of a crime?
No, sir.
Okay. All right. And do you recall around the last time that you saw Jason?
Yes, sir. It was about 7:45 p.m.
Okay. It's about 7:45 a.m.?
Yes, sir.
I mean PM. I'm sorry.
PM,
You
yes,
said
sir.
Okay. All right. And tell me, was Haley with him?
Yes, sir.
Okay. Tell me about that interaction.
They wanted to come and give lovings and say goodnight, and they were going home.
Mhm.
I asked Jason, was he driving? And because I wanted his keys if he was. And he said no, that Haley was good. She was driving them. I gave them both love, and he gave my sister love, and Haley and I stood close together at that point, and then they left.
Okay. Now you said you wanted his keys. What made you want his keys?
I've taken keys away from many people
Mm-hmm.
when they're drunk and too drunk to drive, and I wouldn't have let him drove if he was driving. I'd take his keys.
Okay. And when she was there, were you all in close proximity?
Yes, sir.
Okay. And did you feel like was Haley stumbling?
No, sir.
Was she distraught?
No, sir.
Did she have bloodshot eyes?
No, sir.
Did she have watery eyes?
No, sir.
Was she crying?
No, sir.
Okay. And what happened after that? Did Jason do anything else? What were you doing at this time, around this time? Was it,
We were getting the equipment and the tables and chairs moved back into the buildings, and then our customers and so forth, would go back inside and finish the evening out.
okay, so was there like a a street fest that was it kind of shutting down at that point
Yes, sir.
and moving to the inside?
Yes, sir.
Okay. And that's when you interacted with them?
Yes, sir.
Okay. Are you okay?
Yes, sir, I am.
What'd you do to your arm?
I was in a accident and had to have a rotator cuff replacement, and then I broke
Yeah.
my shoulder blade.
A vehicle
Ew.
accident?
No, it was like an ATV accident. My own silliness.
Your own
Howie.
silliness.
Yes, sir. I wanted to show my kids that I was still young and I could have fun.
You wanted them to, what were you doing to show them that you were still young?
Riding a racing little like dirt bike or whatever they're called. I call them ATVs. Everything's an ATV to me.
Okay. Did it get out from under you?
Yes, sir, it did.
Okay. Well, tell me a little bit more about that. What happened?
Well, evidently I hit a rock coming out of the driveway, and with short arms, the wheel turned real quick on me, and I panicked. I was trying to reach the brake, which I couldn't reach, and in the process, I was
Surprised
what we
there's no
call whiskey
connection to
throttling, pulling
relevance.
down the accelerator, making it go faster. I was panicked and didn't even realize what I was doing.
When you say whiskey throttling that, were you drinking whiskey?
Oh, no, sir.
Okay. So you were reaching back, you grabbing that
Yes, sir.
throttle because you couldn't.
I was reaching for the brake, and as I was pulling back on the throttle and going faster. And
And I don't want to talk about your arms. I can't even ride a bike, so I didn't mean to. Okay. So about what time
Okay.
would you say was the end of your encounter with
Sorry,
Ms.
Gabby.
Brown
My hair's gonna drive you nuts.
and Mr. Brown?
7:45, 7:50, right in there.
And I don't know, I may have asked you this already. I'm sorry, it's been a long week. Did you ever see Miss Brown with a drink?
No, sir.
Okay. But it's possible that she was drinking something, right?
I didn't have eyes on her at all times, her or Jason, either one.
Okay. Did you see Jason with drinks?
Yes.
Okay. All right. And were you concerned about whether or not he was going to drive?
Oh, yes, sir.
Okay. I have a moment, Your Honor.
That's probably true. That's probably true, but everybody probably already knew. Everybody's like, we know what happened. We saw it. We were there. And I understand her wanting to show your kids you're not old. I get it. I've been there. That's right. I wrote a note. I told that computer, no.
Did you interview with Major Christian and Mr. Summerhour sometime at the House of Brews?
Yes, sir, I did.
Okay. And you give them their account,
Yes, sir.
the account of what you saw that night?
Yes, sir.
And did you observe anything that would lead you to think that Haley Brown was impaired to drive or intoxicated?
No, sir, not at all.
Yikes.
Okay. And did you observe anything that concerned you about whether or not she could drive?
No, sir. She was fine.
Okay.
Bruce.
In my opinion, she was fine.
Okay. And this was about 7:45 p.m.?
Yes, sir.
Were you gonna take those keys if you had to?
Oh, yes, sir.
Okay.
In a heartbeat.
Okay.
I've done it many a times.
Okay. Thank you, Ms. Connor. Mr. Arnold may have some questions for you.
Mr. Arnold, you have
The problem is it doesn't matter what she observed. How you gonna get around the BAC? There's no way around that unless they have some surprise witness that wants to say the whole system doesn't work of testing the blood. She could appear straight. She could have done all the standardized test, whatever, passed them all,
any
and her
questions?
BAC'd still get her.
Just a couple, Judge.
Before I start, Ms. Connor,
Yes, sir.
we know each other, don't we?
Yes, sir, we do.
Uh, I've known you for probably about 10 years from when you worked at Hole in the Wall in Waverly. Is that fair?
Yes, sir.
And we're actually personal friends. Would that be fair?
Yes, sir, we are.
I just didn't want to not say that. And, is it okay if I call you Sue?
Yes.
Okay, thanks. I actually, until just now, didn't know that your real name was Melinda.
I'm usually in the doghouse when I get called Melinda.
Fair. So I kind of want to touch on one thing. You say it was about 7:45, you think, when they left? Is that right?
Yes, sir.
Now, when they left at 7:45, was Haley drinking anything?
No, sir.
And if she was leaving, to your knowledge, would there be any way or reason she could have drunk anything after 7:45?
No, sir. They got nothing from us.
Okay. And that's because y'all were taken outside down at that point, weren't you?
Yes, sir.
Now, I know you've told us what you remember, but would it also be fair to say that Oktoberfest at that time for House of Brew is a pretty big deal?
Yes, sir, it is.
And it required you to go not only outside, but also all over on the inside of the restaurant.
Yes, sir.
Got an idea? I mean, I know you said a lot.
Good
Any
morning
idea
there.
how many people were there?
No, sir. The street was packed, the bar was packed. I mean, there wasn't even hardly standing room in the House of
That's a
Brews.
miracle.
And not to be upsetting in any way or whatever, but in a crowd of people, you can't necessarily see everywhere in the crowd, can you?
That's very true. No, sir, you can't.
But I mean,
Well, and I'm short too, so that puts me at a disadvantage.
yeah, I didn't want to ask it that way, but and then I guess the last thing would be, and I know you said you had a lot of experience with I mean, obviously, I've known you as someone who worked in a restaurant, and you're still working in a restaurant 10 years later.
Yes, sir.
Would it be fair to say sometimes that if two people are drinking together and one of them's a lot drunker than the other, the person who's less drunk might seem less drunk than they are? Is that fair?
I guess. Yes, sir.
I mean, if I see one person, no kidding, has to be supported, is falling down, the other person isn't in that state, might I make a mistake about how drunk the better person is?
I mean, anything's a possibility, but I was face to face, cheek to cheek with Haley. We were talking in very close proximity. I smelled nothing on her breath. Her eyes weren't weird, and she was not stumbling when she walked.
So would it be very surprising to you to find out that 3 hours after you saw her, her BAC was twice the legal limit?
Yes, that would be very surprising.
Thank you. I don't know if Mr. Sprout will have some follow-up.
And Miss Sue, can I call you Miss Sue?
Yes, you can.
Okay, I get in trouble for that the other day. Why would it be surprising to you that her blood alcohol was that high?
She showed me no signs, no symptoms, none of that to be intoxicated at that rate or that point.
And you say you were face to face, cheek to cheek with her. Was she confused about anything?
No, sir.
Okay, so did she know who you were?
Oh, yes, sir. Mama Sue.
Okay. And again,
I agree.
so did her motor skill, do you know what motor skills are?
Yes, sir, I do.
Okay. Does that play into whiskey throttling?
That's part of it.
Okay. But you know what motor skills are?
Yes.
Right? Okay. So she didn't seem to have any problem with her motor skills.
No.
Okay. And you General Arnold asked you, if you viewed somebody that was way drunker than the other person, would that skew your reality? That's fair that sometimes that might happen, isn't it?
Yes, sir.
Okay, but you specifically knew Jason and Haley, right?
Yes, sir.
Okay. So do you have any doubt whatsoever that she was okay to drive when you talked to her at 7:45 PM?
No doubt at all, or I'd have had them keys.
Okay, thank you.
You're welcome.
Good
Arnold,
morning,
any other
Ronnie.
further cross?
Just one, just one.
Maybe.
But to be totally fair, you didn't administer a blood or breath test to anybody there.
No, sir.
And your experience doesn't include comparing how people look and act to specific blood concentrations, does it?
No, sir, it does not.
That's all.
Uh-oh.
Just briefly, is the first time you've ever been asked to do that, was that by General Arnold just a minute ago?
Yes, sir.
Okay, thank you.
Sorry.
Anything else?
No.
Thank you, ma'am. You
Judge's
may
light.
step down and you are released from your subpoena.
I have to tell you
Mr.
guys,
Scratch, you may call your next witness.
I have no idea the population of this town that this happened in, but I think if you were to witness a trial in my town, this is exactly how it would go. Exactly. Because I have not lived here all my life, but a lot of people have, and they grew up here. Their kids have now grown up here. Their grandkids are now growing up here. They know everyone. So yeah, this is just like watching court in my town for me. And it was a good game of waitress.
Recess.
Ladies and gentlemen, we'll take a short recess. If you'll step across the way, please.
Uh-oh. Oh, I
Brief
know.
means different things to different people. What are we talking about?
Hope not over 5 minutes.
5 minutes it is. We shall reconvene in 5 minutes.
All rise. This court's now in recess for 5 minutes.
Yeah, it's been like 2 sheriffs ago now, but when he ran for sheriff, his kids and some of his kids and my kids were the same age, and he's one of those people that grew up in this town. He went by a nickname, so it wasn't. I'm not going to say it, but it wasn't mean. But it just wasn't. You shouldn't call the sheriff that. So it was really hard to be like, "Hey, sheriff, you," because I never called you by your first name, and I'm not going to call you by your nickname. Alrighty, let me fast forward here. Oh, not too much, not too much. If my dog saw that
Mr.
right now.
Spratt, before we summon the jury again,
It's
do you
safe,
need
safe.
to address the issue, I think, of your client's testimony?
Do your honor that my client's going to testify.
She is going to testify.
We're gonna hear from her.
We are ready for the jury.
We are gonna hear from her. Poochie. This guy is also tall.
All right, thank you, ladies and gentlemen. Mr. Spratt, you may call your
I
next
didn't
witness.
know him when he was a child. I
Defense
didn't know
calls
how he
Haley
was.
Brown.
Brown, if you'll come around, please.
Oh, Mrs.
Raise your
Kravitz.
right hand.
solemnly swear affirm testimony given in this case to be the truth, the whole truth, nothing but the truth, so help you God.
All right, here she is, the driver, Miss Haley Brown.
Good morning, Ms. Brown.
Good morning.
Um, Could you state your name and spell it for the court reporter, please?
My name is Haley Brown, HAILYBROWN.
And Ms. Brown, how did you know Jason Brown?
It was the love of my life.
Were you engaged to be married to him?
Yes, sir.
And how long were you guys together?
1,334 days.
Have you, do you calculate that number daily?
I have. Yes, sir.
I'm going to take you through some things here. Have you been able to see and observe everything that's gone on during this trial?
Yes, sir.
Okay. And have you watched the videos that have been played at this trial?
Yes, sir.
I agree.
And do you recall interviewing with Major Christian and Sergeant Summerhour?
Yes, sir.
Okay. Now, I'm gonna start with I'm gonna start on October 3rd.
Yes, sir.
Okay. You recall what happened on October 3rd?
Yes, sir.
Okay. All right. How did your day start off?
As normal. Woke up around 6:30 in the morning. I knew that I needed to go see my grandmother. She was on hospice. My sister had not been with her, so we had made plans to go see her that morning. We decided to stop at McDonald's that morning. It was around 9:30.
I think so. I didn't hear
To
her
get breakfast
exact
for
number.
ourselves and everyone at the house. We stayed there as long as we could. And then I believe I came home around 1:30. Jason was home. He was cleaning and rearranging the shed that day. We had a lot of trash to take off just because of that rearrangement. We decided to ride together to take the trash off.
Was that in your car?
That was in his truck.
Okay.
Yes,
I'm sorry.
yeah.
Okay. And then what?
We decided, it was actually his idea, surprisingly, to have a date night,
Okay.
to go to Dixon. We knew about Oktoberfest. And we made plans and went up there. But first, we went to Xander's
Okay.
to have dinner, an early dinner.
Okay.
That was around 4:00.
Okay. And what all did you eat?
We had an appetizer, consisted of like cheesy bread,
Mhm,
and I had a salad,
mhm.
and then we both had personal pizzas.
Personal pizzas.
Mhm.
Did you drink a beer while you were there?
Yes, sir, I did.
Had you drank anything prior to coming up there?
No, sir.
Who drove to Dixon?
Jason did.
Was that in your car?
Yes, sir.
Was that the Ford Focus that we've seen there?
Yeah, yes, sir.
Okay. All right. And so was everything going okay at dinner and everything? Did y'all have a nice time?
Yeah, yes, sir.
Okay. And so what did you do after that?
We walked from Xander's down to Oktoberfest or House of Brews.
Okay. Did you hang out inside and outside a little bit?
I was more outside. The live music was outside. A majority of the people were outside. It was a really nice day, so we hung out outside a majority, but I did go inside sometimes. Yes, sir.
Did you have some drinks over the course of the time you were there?
Yes, sir.
Okay. At at the time this happened, and I believe Major Christian asked you, did you hold a bartender's license
Yes,
at that
sir.
time?
Yes, sir.
Okay. And so take me through what you recall about the evening after you left Xander's while you were at the House of Brews in the Oktoberfest. What do you recall about that? Who did you interact with?
Oh, okay.
Sorry.
No, you're good. Mama Sue.
Okay.
We saw her. We knew that she would be there.
Mhm.
We specifically looked for her.
Mhm.
Found her, hugs and love, as she says.
Mhm.
And we were listening, to the music and looking for other people to see if we knew. There was a lot of people there looking to see if we saw other people. I noticed Katie Joe. She was there.
Okay.
And she had done my stepsister's makeup for her wedding that day.
Okay.
And so I approached her, and she was a few grades younger than me, so I knew about her. We knew about each other. So I asked her about the makeup, told her it looked really good, just huge
Your
compliments.
sister's makeup?
Oh, no, Katie Jo. Yes, my stepsister's makeup. Yes, sir.
Okay,
Yes,
alright.
yeah. The makeup looked really good.
Mhm.
And then I also saw Haley Weaver there.
Mhm.
Talked to her. And then as I was talking to Katie Jo, Haley approached us both. Didn't know you knew each other, and
Mhm.
we we did have that conversation all together.
Okay. And the whole time that you were there, were you and Jason together all the time, or was he drinking while you were there?
Yes, sir, he was. We were together a majority of the time besides going to the bathroom.
Okay.
Mhm.
All right. And at some point, did his behavior change?
Yes, sir.
Okay. Tell me about that.
Jason is a very reserved type of person. He's to himself,
Mhm.
typically.
Mhm.
And when he has alcohol or when he drinks, he becomes very loud and very loose as far as his body goes. He was hugging and leaning and just getting very touchy and feely with me, talking to other people, which he normally wouldn't.
Okay. Did he talk to anybody that made you jealous that night or anything?
No, sir.
Okay. I wanted to make sure where you were
Yeah, no,
going
sir.
with that. Okay.
No.
So go ahead. I'm sorry. Go ahead.
Hanging on Mama Sue as
Uh-huh.
far as,
Okay.
because he was gonna fall. He was stumbling. Yeah.
Okay.
Yeah.
All right. Now, going back to Katie Joe, she's the one that did your sister's makeup?
Yes,
Is that
sir.
right?
Yes,
Okay.
sir.
All right. At some point, did you take a selfie with Katie Joe?
Yes, sir.
Okay. Around what time was that?
7:28.
7:28 p.m.
Yes, sir.
Okay. And you watched your interview with Major Christian and Sergeant Summerhour, right?
Yes, sir.
Did you mention that picture to them?
Yes, sir.
Okay. All right. Now, do you recall hearing Major Christian encourage you to have some sort of counseling after this all happened?
Yes, sir.
Had you already done that?
Yes, sir. The Thursday after.
Were you on any kind of antidepressants, mood things after this occurred?
Yes, sir.
Okay. All right. Did you attend grief counseling?
Yes, sir.
And as part of that grief counseling, were you trying to work on memories of this?
Yes, sir.
Okay. All right. And so, and I didn't mean to jump around on you, but so you taking this selfie and then what happened?
I took the selfie and I sent it to Katie Jo. That's how I got her number. She's like, send that to me. And I'm like, yeah, of course.
Uh-huh.
And so I get her number and I'm working on sending it to her. And as most people do, you look at yourself in that photo. You're like, do I want to send this to this person? Like, do I look good? And everyone does it. They check out the photo.
Well, is it difficult to call it a selfie when there's more than one person in it? I've
Yes,
always-
yes,
okay.
sir. I think we call it selfie because you do use the self front camera.
Okay.
Yeah.
All right. So, all right. So you were looking at it. Were you looking at, you sent it to her?
Yes, sir.
Okay.
Yes.
And what time did you send it to her?
Within the minute.
Okay.
Yeah, I've taken the photo. We were looking at it and she's like, then send that to me. And shortly after that, within a few minutes.
Okay.
Yeah.
As part of your grief counseling, did you go back and try to make a timeline to refresh your memory as to what was going on?
Yes, sir.
Okay. And have you been able to completely recover everything?
Not completely. There's about a 15-minute
Okay.
time block there.
At some point, when you and Katie Jo were looking at this, or were you looking at it by yourself later on your
Yes.
phone?
After I had sent it to her, I was zooming in on it because someone was in the background. Jason had tried to photobomb the picture.
Uh-huh.
And someone was in that background and I was zooming in because he looked familiar
Mhm.
and I didn't know who it was. So I was zooming in on that specific man.
Mhm. Okay. Did you ever figure out who he was?
Later. Yes, sir.
Later, as in, when you say later, was that after you had interviewed with them?
Way later after that. Yes,
Okay.
sir. Yes, sir.
So you all right. And who was it?
His name is Sam Moore.
Okay.
I know that just from Facebook. I have Haley Weaver on Facebook and they have mutual friends and I saw him in a photo and that's how I figured that out.
Okay. And at some point, did Jason see you zooming in on this?
Yes,
And
sir.
All right. And what happened?
He became jealous,
Mhm. Okay.
asking me, who is that? Why are you zooming in on that person? Do you know them? Who is that?
Mhm.
And I'm like, I don't know. I didn't know who it was.
At the time, that night?
At the time, yes, sir.
Okay.
I did not know who it was. He did look familiar. That's why I was zooming in on him and trying to figure out who that was.
Okay.
But he was very concerned that I was zooming in on that man.
And was he agitated?
Yes, sir.
And so when did you say the picture was taken again?
7:28.
Okay. And at that point, what do you recall next?
Him getting agitated, me trying to change the subject, closing my phone out, accidentally taking a screenshot, trying to avoid that
Okay,
conversation.
let me stop you there. Have you characterized that as an accidental screenshot
Yes.
before?
Yes,
Okay.
sir.
And did you mention that accidental screenshot during your interview with Major Christian?
Yes, sir. I believe I did.
At that time, did you know why it had been taken? The accidental screenshot?
Other than it was an accident. No,
Okay.
sir.
All right, and I'm sorry to interrupt you. I just wanted to clarify.
Yeah.
So go ahead. What's the next thing you remember?
Just being on the sidewalk, everything's starting to shut down.
Mm-hmm.
Seeing Mama Sue,
Mm-hmm.
getting ready to leave. Other
Mhm.
people were going to like House of Vines. We decided not to do that.
Mm-hmm.
But just getting ready to leave. And
Okay.
that's it.
Do you remember getting in the vehicle?
Sir.
You don't remember that?
No, sir.
Okay, so you remember seeing Mama Sue,
Mm-hmm.
and you remember are you a private person?
Yes, sir.
Okay. Does it upset you to more or less discuss or have altercations or anything like that in public?
Yes, sir.
Okay. All right. So you remember seeing Mama Sue, and then what's the next thing you remember?
I remember hitting something, hearing that.
Mm-hmm.
I remember seeing Jason beside me, slumped over,
Mm-hmm.
trying to wake him up,
Mm-hmm.
and someone beating on my window, trying to get my attention so I wouldn't look at him.
Mm-hmm.
And I just remember trying to wake him up. Baby, please wake up. Please wake up. He wouldn't wake up. And then them getting me out of the car, trying to figure out, what my name is.
Were you saying they were trying to
The
figure it-
women, yes, sir.
Oh.
The women that were there. Initially one and then another one. Telling me that I flipped my car.
Mhm.
And
Did you know at that time whether you had flipped it or not?
No, sir.
Okay.
Just being on the scene of the accident. That's what I remember next.
Do you remember sitting in the grass?
Yes, sir.
Okay, what do you remember about that?
Just being so upset, pulling at the grass,
Mhm.
screaming, crying.
What were you worried about anything?
Jason?
Okay. And this is when you were in the grass?
Yes, sir.
Okay. All right, go ahead.
I just remember the women being in my face, trying to figure out who I am, if I'm okay,
Mm-hmm.
and just being concerned about Jason.
Mm-hmm.
They contacted my mom, and then I remember wanting my mom, my sisters, just family, someone to console me.
Mm-hmm.
Just multiple people there, police officers, fire, EMS.
Were there a lot of people talking to you?
Yes, sir.
Okay.
Yes, sir.
All right. What do you recall about that?
Just as far as just
Well, did you know how many people were talking to you and asking you questions and what was going on?
there was multiple people,
Okay.
and so also I was on my phone.
Okay.
So yes,
Uh-huh.
multiple people.
Did you repeat anything back that anybody said to you?
Yes, my stepdad Randy was asking me, Haley, where are you at? And I'm like, where am I at? You're in Dixon. I'm in Dixon.
Okay. So you were talking to, and is Randy Brassfield, is that correct?
Yes, sir.
Okay, and then that's Mr. Brassfield back here.
Yes, sir.
All right, and so you were on the phone with him.
Yes, sir.
So, and you saw the video, right?
Yes, sir.
Okay, so you were repeating things that other people were saying to you.
Yes,
Is
sir.
that what you're saying?
Yes, sir.
Okay, so go ahead with that. What's the next thing you remember?
I just remember asking if am I going to the hospital? Because I was asked that, am I going to the hospital? Yes, you're going to the hospital. Likely you're going to the hospital. Which hospital? Horizon. And then, just asking me multiple questions, the police officer did.
Mhm.
People asking me if I'm okay, trying to get me in the ambulance. Them checking me out as far as injuries and things like that go. Yeah.
Do you, do you recall being in one ambulance and then going to another ambulance?
Yes, sir.
Now, do you recall that? Do you recall that from memory or from what you've seen up here? Or both?
Both.
Okay.
Yeah.
All right. Do you recall somebody in that ambulance telling you something?
Yes, sir.
What did they tell you?
That Jason was dead.
And how did that make you feel? At the time?
Yeah.
At the time.
Just awful. Just so broken and awful. And just it's very indescribable, but just awful.
And I mean the effect on you.
And also I felt just
No, you go ahead.
suicidal. I didn't want to be there anymore.
Okay.
I
So-
wanted his life traded for mine.
And did you say that night?
Yes, sir. Multiple times.
Okay. Did you say that? Did you start saying that after you were told that he was deceased? Is that when you started saying that?
Yes, sir.
Okay. Now, at some point, you became suicidal. Were you on the phone still when you were in the ambulance?
Yes, multiple times I was on the phone. Yes, sir.
Okay. All right. And at some point, you became confused, right?
Yes, sir.
Okay. Tell me about your relationship with your natural father.
It's not the best
Okay.
up until now.
Mm-hmm.
He has been in and out of my life. He's been to jail multiple times.
Mm-hmm. Was
Just-
there a specific event early on in your life?
Yes, sir. He tried to kill himself.
Okay.
He tried to commit suicide.
Okay.
And I remember being there for that. Going to the hospital, seeing him on a ventilator, them pumping his stomach. It's probably before this accident, the most traumatic thing that I've been through.
And do you believe that this had something to do with why you were confused and confusing these things?
Yes, sir, absolutely.
Okay. And what did you want more than anything while you were in that emergency room?
For Jason to be alive and for them to trade my life for his.
And if you couldn't do that, were you wanting somebody else?
Yes, my mother or my sister, mainly my mom.
Okay. Now, you refused some medical treatment. Was there a reason that you were doing that?
Yes, sir. I didn't have health insurance at the time. And I know how costly it is, healthcare is.
Okay.
And that was why I was refusing it.
Okay.
I didn't have the money.
Did you feel physically injured?
No,
Okay.
sir.
And you weren't physically injured, were
Right.
you? All right. Now, do you recall Sergeant Summerhour coming in to ask for the blood?
Yes, sir.
Okay. And at the point when that happened, had your mom entered the room right before that?
Yes, sir.
Did you calm down immediately?
Yes, sir.
Now, and I've asked you about this grief counseling. Is part of that, is that where you were trying to recover memories? Is that
Yes, sir.
fair? Okay. And to this day, can you remember what happened in the car with you and Jason?
No, sir.
Okay. Now I want to ask you a couple of things. How many speeding tickets have you had?
Say 3 to 4.
Okay.
Mhm.
Around that time?
Yes, sir. Yeah.
Okay. And did you ever, any of those times that you pulled over, were you ever drinking?
No, sir.
Okay. So would you describe yourself as having a lead foot?
Yes, sir.
Now, did you listen to and I've asked you this question again, but when I'm jumping back and forth, I'm going to refer to what I'm going to ask you about.
Yes, sir.
The interview that you gave with Major Christian and Sergeant Summerhour. Do you believe that your speed was a factor in this wreck?
Yes, sir.
Do you believe that the speed ultimately caused the wreck?
Yes, sir.
Okay. Do you believe that your ingestion of alcohol whatsoever caused that wreck?
No, sir.
And do you recall Major Christian saying he was going to try to interview witnesses
Yes, sir.
to support what you just said, right?
Yes, sir.
Okay. He was more than fair with you, wasn't he?
Yes, sir. Absolutely.
All right. And do you recall that he doesn't know what caused the speed? Do you recall him saying that?
Yes, sir.
Okay. And do you recall him saying that you had been upfront and honest?
Yes, sir.
Okay. Now, you did not recall during that interview the selfie and Jason becoming upset about the selfie.
Yes, sir.
Okay. But you did recall the selfie itself. Is that fair?
Yes, sir.
Okay. And did you zoom in and look at this? How many times have you played this out in your mind?
Hundreds.
And how many days did you say this had been that you've known Jason?
1,334.
Have you ever told me that before today? Have you driven back through the route?
Yes, sir.
Okay. Were you familiar with Walnut Street before you went down Walnut Street?
No, sir.
And you have driven back down through the route?
Yes, sir.
Is there a speed limit sign between where you told Major Christian you were parked and where the wreck happened?
No, sir.
Have a moment, Your Honor.
You may.
So, Chrissy, one count is vehicular, I believe, homicide with recklessness, and the other count is vehicular homicide with intoxication, and then a DUI, and then not DUI, then DUI.
Ms. Brown, did you hear Agent Bramlage testify as to what your blood alcohol was?
Yes, sir.
Do you believe that was possible?
No, sir.
Were you intoxicated that night?
No, sir.
And you don't remember what happened in the car?
No, sir.
Thank you, Ms. Brown. I'll pass it with Ms. Brown.
Arnold, you may cross-examine.
This would be terrifying. Because Adair's right. They're not going to be nice.
Morning, Ms. Brown.
Good morning.
Now, you talked about this selfie at 7:28.
Yes, sir.
Okay. And you heard Ms. Sue testify that they closed down the Oktoberfest round about 7:45, and that's whenever you guys left to walk to the car.
Yes, sir.
And maybe I'm putting words in your mouth, but you remember from 7:28 to leaving the sidewalk pretty good, don't you?
Yes, sir.
Okay. So let me ask you something. Did you drink anything from 7:28 PM to when you and Jason left House of Brews?
Not to my memory.
So from the selfie to things closing down and y'all leaving, you did not have a drink.
No, sir.
Object, Your Honor. I think she said she can't remember. I think that was asked in
Cross-examination, overruled.
So no, sir, it was your answer, I believe.
Not to my knowledge.
Now, you remember the interview with the officers, right?
Yes, sir.
Okay. Do you remember finding 2 purchases for alcohol from House of Brews, one for 27 something, one for 29
I
something?
did not say alcohol. I had 2 charges on my credit card.
Okay, but you're not sure what those are for?
No, sir.
But you did tell them you had a shot of Crown,
Yes, sir, I did.
at least one that you
I
remember.
told them that. Yes, sir.
Okay. And you did have one of those brews. One of those
At
brews.
Xander's.
Mhm.
Hmm.
But do you remember telling them that you at least bought another one at House of Brews?
And handed it to Jason. Yes, sir.
Do you also remember telling them that usually if you were going to drink either beer or whiskey, it's going to be one or the other?
Yes, sir, I remember that.
Okay. So given that you passed off a beer and drank a whiskey, would it be fair to say this would have been a whiskey night?
This was a date night. This is not a whiskey night. No, sir.
Okay, but you had a whiskey
I did.
and you decided not to have beer.
Yes, sir.
And you normally do one or the other, but not both.
Yes, sir.
Okay. Sitting here now that you've done all this work on memory, have you been able to recover any more memory about the things that you drank before 7:28 that night at House of Brews?
No, sir.
Do you still remember at least a shot of whiskey and passing off a beer?
Yes, sir.
But still today, that's all you remember.
Yes, sir.
Now, you testified just now that you were basically uninjured physically that night. Is that fair?
Yes, sir.
Were you discharged that night from the hospital?
Yes, sir. And I returned the next day for a panic attack.
Okay. But in terms of the physical injuries from the hospital itself, ultimately, when they were able to establish how you're doing, they discharged you, didn't they?
Yes, sir, they did.
Now, when Mr. Spratt asked you if you had any further recollections about the cause of your speed, right, you just now said no. That you haven't had any additional recollections. Do you remember telling Mr. Spratt that just now?
I'm sorry, repeat that?
He asked you if you had any additional memories about what caused you to be driving so fast,
Oh, yes.
and you said that you don't.
Yes, sir.
Okay, but let me ask you, was anybody driving that car other than you?
No, sir.
And when you got those 3 or 4 speeding tickets, was anybody driving the car but you?
No, sir.
So would it be fair to say that your driving fast is probably the cause of the speed of the car?
Yes, yes, sir.
And so sitting here right now, it's your recollection that from 7:28 PM, you didn't have anything to drink,
Correct.
but you don't have any additional recollection about what you had to drink before 7:28 PM.
Not specifics.
So, and I know you already said that you didn't think you were drunk. I understand.
Yes.
But sitting here today, are you saying that you only had one shot at House of Brews and one beer at Xander's?
I'm saying that's what I remember.
So you're not saying that you couldn't have had more?
I'm saying that's what I remember.
Okay,
Yes, sir.
let me try it another way because I don't think I'm getting at it very good.
He's just not getting the answer he wants.
You're not saying that you remember definitively that you didn't have more. You're just saying the only ones you remember are those. Correct?
Correct.
So as far as your memory is concerned, you could have had more. You have no memory one way or the other.
Object, this has been asked and answered
She
several
should have
times.
stuck with her answer. That's all I remember.
Overruled, cross-examination.
Can you repeat the question, please?
So you don't remember more than those, but that's not the same thing as saying you remember for sure you didn't have more than those. Do you understand the question?
Yes.
So today you're not saying, I, Haley Brown, remember that those are the only drinks I had. You're just saying, those are the only drinks I remember.
Yes,
Correct?
that's what I'm saying.
Okay.
I think she's doing okay. He hasn't
And if
came at her
the
yet.
science said something else, you wouldn't necessarily be in a position to dispute that then, would you?
I don't agree with the science.
That's fair.
She has stuck to that one shot, one beer.
Those are my questions.
Wow.
Be right.
Ms. Brown, would you feel better about the science if you had a blood sample from about 30, 40 minutes after that wreck than you do about what you ended up with here?
Yes, sir.
Okay. And the, you don't recall everything about what happened, right? As far as from the time that selfie was taken until you left?
Yes, sir.
Okay. And, but is it your testimony that you think it was impossible that you were double the legal limit when you were driving this
Yes,
thing?
sir.
Okay. And what do you know caused the wreck? What can you say for sure caused that wreck?
Speed.
I'm sorry, Ms. Brown, I hate to do this. It's the same question as, one of the same questions asked Ms. Sue, okay? Have you ever participated in a study where you compare the amount you've drank to a known blood alcohol content?
No, sir.
Okay, so you've never participated in a study where you had, say, 2 drinks, and then they tested your blood and told you what the BAC was, and then you had 2 more and tested your blood and they told you what your BAC was?
No, sir.
So honestly, sitting here right now, you don't know how many drinks it would take to take you to the legal limit, do you? The legal limit I'm talking about,
Right.
not how
I've
you
never
feel.
been in a study like that. No, sir.
And so you wouldn't have any idea how many drinks it'd take to be double the legal limit.
It'd be interesting to do.
I've never been in a study like that, so no, sir.
Okay. Thank you. That was it.
She handled the state quite well, I
Brett,
think.
anything else?
Maybe have a moment, Judge.
mean, I don't know. Never done that study. I don't know. Could take 1, it could take 20. Oh, don't do it. Please tell me you didn't wear your pajama pants to Walmart. And if she's in her pajama pants, don't do it. Don't do it.
Ms. Brown, would you remember if you drank several gallons of beer in that 20 minutes?
Yes, sir.
Okay, do you believe you drank several gallons of beer in that 20-minute period?
No, sir.
Those are my
We're with you, Stormy.
No follow-up, Judge.
Thank you, ma'am. You may step down and have a seat by your order.
The one place that I think she's being absolutely truthful is that she did not have anything from 7:28 to 7:45 because they were shutting down. So it would make sense to me that she did not have anything then. Because if they're shutting down, last calls probably happened, and you aren't just, doubling up to make sure you have something for the drive home. Gabby. So I believe her on that point. It is super hard to get past the BAC. I do think it was good of her attorney to come back up and say, would you have rather had it just right after the accident happened? You would feel more comfortable with the result. That's why she was saying she didn't trust the science, because the lapse in time between when the accident happened and when they actually took her blood. So it all just, there's so many variables there. I don't know. But I think she did a good job. The state had a hard job because you come at her too hard, you're just going to look bad, because this woman is done a horrible thing and she's going to pay for it, regardless of what the jury does. So if he comes at her too hard, that could tick the jury off and be like, all right, she's suffered enough, we're done. But I think he did okay, but I think she handled him quite well. I don't think she did bad at all. Ronnie, I am with you. I go to Walmart when I have to go early. Like by the time that parents have dropped the kids off at school, but before they've had time to go home and get ready for the day to come to Walmart. Although most people don't get ready for the day to go to Walmart. And Gabby's Crocs are ready to rock.
Mr. Spratt, you may call your next witness.
Your Honor, the defense may I have just one moment. Your
All
Honor.
right.
Your Honor, the defense rest.
There we go.
This is rested. State have any rebuttal proof?
No, Your Honor.
All right. Ladies and gentlemen, we're going to go to closing arguments now, and then after closing arguments, I'll give you a break before I start reading you the 17 pages of instructions. But I want to give the lawyers their opportunity. Also, how you want to make adjustments to the podium.
Your Honor, may the state visit the little lawyer's room before he begins his closing argument?
I'm sorry, can the state what?
What?
The state needs a restroom break, Judge.
He's going to pee, Judge. He's just not adult enough to stay,
Received
so.
Paper moon with Adam O'Neill and Ryan O'Neill. He said, I believe you've got a bladder the size of a kidney or a peanut or something like that. There was a line in it.
Little lawyer's
Yeah,
room.
let's go ahead and take our restroom break, and then that way, after closing, I'll go directly into reading this charge. We'll be in recess for 15 minutes.
All rise. Court's now in recess for 15 minutes.
Come on. Is that your reply to the lawyer wanting to go to the little lawyer's room, Gabby? If Gabby was Judge Gabby, I'm not in the mood. Just get effed. That'd be epic. That would be epic. Yes, just say, Can I have a restroom break?" You didn't have to maybe he did have to dance around it because he really had to go, but just, "Yes, I have to pee, judge." I mean, come on. We're all adults. We can say it. Yes. The Can I go? I need to visit the
Ladies and
little
gentlemen,
lawyer's
I'm
room.
going to ask you, before I even really start talking here, to go back to that first day when I picked the jury, and I told you before any of this started that this was going to be an emotional case, that it was going to be a difficult case, that the defendant charged in this case was upset about killing the victim in this case,
That's hilarious.
and that all of those things would be involved. And what we also discussed was that you would get instructions of law from the court in the jury instructions, and that all of the proof was going to come from the stand, and that the proof was going to be required to prove the elements of an offense and nothing else. I want to remind you guys about that, because that is exactly what you're about to be asked to do. And when I say that the instructions of law, that the laws of the state of Tennessee are contained in the instructions, what that includes is the following admonition. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality. When the instructions say law, they mean the instructions that the judge is going to read you. And when the instructions say facts, they mean the proof that was provided by the witnesses and in the exhibits to this trial. So what is the proof in the case, and what are the questions that you're being asked to answer and the questions that you're not being asked to answer? In the first count of this indictment, the defendant is charged with vehicular homicide by impairment.
Oh, sorry,
In order to
impairment,
prove that charge,
not
the state
intoxication.
has to prove that the defendant killed someone by the operation of a motor vehicle. That is the first element. The first element there means that Haley Brown was driving a car and that her driving of a car resulted in the death of a person. And it did, to the extent to which that is not really in dispute in this case. Jason Brown was Haley Brown's passenger on October 3rd, 2020 at 8 p.m. when she exceeded the critical velocity of the curve on West Walnut Street, slide slipped into a yaw, and struck a light pole almost exactly where Jason Brown was seated. The tire in his side of the car. It slid along his side of the car as the car rotated around the pole. And in that event, Jason Brown's head struck the interior of that vehicle and he died virtually instantly. You have the testimony of Dr. William McLean from the ME's office that, as he called it, eggshell fracture to the brain would have been immediately fatal and was the cause of death of Jason Brown. So that's the first element. And I have to tell you, that element, I would submit, is proved beyond a reasonable doubt by the road evidence, by the testimony of Major Christian of the Dixon Police Department, by the testimony of the medical examiner. So the next thing that has to be proved is that Haley Brown's operation of that vehicle was reckless. We know from Major Christian's testimony that her operation of the vehicle was such that it exceeded the vehicle's ability to negotiate the curve. He gave us a figure of 56 to 58 miles an hour from measuring the chord and middle ordinate of the yaw in this case. And he explained that he downloaded the CDR data from the vehicle, and the vehicle's own recording of its speed supported this speed assessment within a couple percent tolerance. I submit to you that going 58 in the middle of the city of Dixon, where the speed limit is 30 and the road is completely surrounded by houses, is in fact reckless operation of a vehicle. Now I submit to you further, and this goes a little bit to the third element, so I hesitate to mention it, that getting behind the wheel of a car under the influence of alcohol and marijuana is also reckless. So I think that second element is doubly met by the facts in this case.
I don't think they
And
proved
then the third
intent.
element of vehicular homicide by intoxication
Yes, this
is
is
that
state's closing.
Haley Brown was intoxicated at the time she was operating the vehicle,
You're good.
and that her intoxication was the proximate cause, the but-for cause of Jason Brown's death. You'll get an instruction explaining proximate result. What we'll tell you is that one thing is the proximate result of another if it wouldn't have happened if that earlier thing had not happened. So in terms of proximate result, what the state is required to prove is that but for Haley Brown striking that light pole, Jason Brown would be alive, and but for the fact that she was intoxicated, she wouldn't have struck that pole. That is the third element. And so let me talk a little bit more about that third element, because I think a lot of the argument here is going to be on intoxication. And that was the bulk of the state's proof yesterday, the bulk of our proof on the second day. Here's what the proof tells us. The proof tells us that almost exactly at 8 p.m., Haley Brown operates the vehicle in such a way that it strikes that pole and kills Jason Brown. That's 2000 hours. From 2000 hours to 2248, you heard from a series of witnesses and watched, admittedly, pieces of a tape that is a continuous tape, but we didn't play all of it because that would have been 3 hours of tape to play for you guys. But she was continuously in the custody of and control of private citizens, EMTs, and police officers who testified. And from 8 p.m., from 2000 to 2248, when her blood was drawn, she consumed no alcohol and she smoked no marijuana. We know that by our own eyes, by our officers' own eyes, by their testimony. We know that. In spite of that fact, her blood alcohol content at 2248 p.m., as determined by the Tennessee Bureau of Investigation expert toxicologist, 0.161 BAC. We heard April Bramlage testify that is twice the legal limit here in the state of Tennessee. Now, there was a lot of confusing conversation from the cross-examination about curves and whatnot. But I don't know if you guys paid attention to this. When I pointed out to Special Agent Bramlage that there was no consumption from 2000 to 2248, she was able to say a lot more about what it would be like at 2000. The first thing she said was, it would be higher then. Without knowing that information, that there was no consumption in that almost 3-hour period, right? She had to admit, could be higher, could be lower, could be the same. But once she had that additional piece of information, she said it would be higher than. Here's why she told us that. She gave us the reason. She said absorption, the first part of that curve that was shown in cross-examination, takes at most 30 minutes to 1 hour after consumption has ceased. If we know consumption has ceased at 2000 hours, right? Then we know absorption is done at 2030, or at worst case scenario, 2100 hours. So we've got 2 hours of what's called elimination. That means at least 2 hours, 2.5 or 2 hours, depending, during which the blood alcohol content is decreasing. In spite of that, at the time of our measurement, we've got twice the legal limit, 0.161. She told us what we would expect if we went back 2 hours from that. 2 hours from that to the peak, she said, would be 0.181 to 0.201, depending on the individual. But that pretty much all human beings will be in that range. Here's the thing, though. You guys now have more information than you had when Special Agent April Bramlage testified about intoxication. What additional information do you have? The defense's own witnesses, Sue Connor tells us that she is sure that Miss Brown didn't have anything to drink from 7:45. So you can go back 15 more minutes. Now we have a full 3 hours of no consumption. And what did Special Agent Bramlage tell us would be a backwards extrapolation, assuming 3 hours of elimination? She said 0.191 to 0.221. But I don't know if you guys noticed, but I spoke to Miss Brown about some of her recovered memories. And she seemed pretty sure that from the time of the selfie, which she remembered very specifically at 7:28 p.m., to the time that her and Jason Lee Brown left that sidewalk at about 7:45, she doesn't know how much she had exactly. She doesn't know what she had exactly, or doesn't remember, right? But she's pretty sure from 7:28 on, she wasn't drinking. So that means the peak couldn't have been later than 8 or 8:30, because April Bramlage told us 30 minutes to an hour. That's a lot of math. The point is this: her blood alcohol content at 8 o'clock when she struck that pole was definitely over 0.08 gram percent, 0.08 of a percent. Definitely. Actually much higher than that, but definitely that. Why does that matter? Because here in the state of Tennessee, the state can prove intoxication in one of two ways. The state can either prove that a person is under the influence of a substance that affects that person's central nervous system to such an extent that it impairs that person's ability to operate a vehicle safely. Or the state is allowed to prove it by showing that the person's blood alcohol content is 0.08 or higher. And my suggestion, and what I'm telling you is, even if you don't think Haley Brown's intoxication at 8 o'clock is such as to have impaired her central nervous system, if you believe her BAC is 0.08 or higher, here in the state of Tennessee, she is intoxicated by definition. Now, I would suggest that we have an abundance of evidence that her central nervous system was also impaired at 8 p.m. When I say we have an abundance of evidence of that, I really have to explain what I mean. Because our toxicologists are very good, they're very careful, they're smart people, okay? They have had a lot of training about what alcohol and drugs do to the human nervous system. But they're testifying in general terms, which means you have to, they can give you symptoms. Special Agent April Bramlage can give you the symptoms of alcohol intoxication, and she did. Special Agent Melinda Quinn can give you the symptoms of marijuana intoxication, and she did. But then what you have to do, just like anything else, right? You know the symptoms of a cold. How do I know if I have a cold? What am I experiencing? You have to compare it to the evidence that you guys saw over the last 2 days. So what are the symptoms that we were given for alcohol intoxication? We were told, lack of coordination, poor decision-making, impairment to memory, difficulty perceiving time and distance, impairment to cognition, learning, and memory. Interestingly enough, those descriptions of symptoms of intoxication apply to both alcohol and to marijuana. So now we ask ourselves, we watched all of this video of Miss Brown from 8 o'clock to almost 11 o'clock at night. Did she exhibit poor decision-making? Well, I don't know. It seems like she did, right? 58 miles an hour in a 30-mile-an-hour zone, to me, is poor decision-making. Losing the critical speed of my vehicle on a curve is poor decision-making. It suggests that I'm not perceiving time and distance correctly. What is time and distance? What is time over distance? It's velocity, it's speed. I don't know how fast I'm going. That is a sign of intoxication by alcohol, and it is a sign of intoxication by marijuana, both of which are found in her blood 2 hours and 48 minutes after she crashes that car. Impairments to cognition, learning, and memory. Ladies and gentlemen, over the course of 2 hours and 48 minutes, she forgot she had killed her boyfriend.
I think
And
that's
then she
trauma.
thought she might have killed her boyfriend and her father. I do not know how much more strongly we could have shown you the symptom of impairment to memory. In her interview with our officers on October 23rd, 3 weeks later, she still has significant memory gaps. Again, a symptom of intoxication by alcohol, a symptom of intoxication by marijuana. Now, that is also a symptom of some other things. It really is. But you guys heard testimony from Miss Brown herself that she was physically uninjured by the wreck. And I think you saw with your own eyes that outside of emotional distress and potentially signs of intoxication, she appears to be physically uninjured. So physical injuries are not the explanation for her loss of memory, for her inability to behave as she otherwise would behave. I would suggest to you that you can see those symptoms in an additional way. If you compare Miss Brown today, or on October 23rd, with Miss Brown in that video, surely Miss Brown is grieving the loss of Jason Brown on October 23rd, 2020, 3 weeks after she killed him in that wreck. Surely she's grieving him then.
And probably still now.
I suggest to you that the difference between her appearance in that interview and her appearance on that scene, that one of the main reasons for that difference is she is displaying the signs of intoxication. But you don't merely have to rely on me for that. Christy Parchment is on the scene moments after the wreck occurs, just behind Melissa Phillips, and Christy Parchment smells alcohol. Now, she doesn't know, she can't say for sure whether it's coming from Melissa Phillips or Haley Brown, but she smells it. And she tells the officers. And we know where the source of that smell comes from, because Haley Brown herself admits that she's been drinking, but she can't tell us how much. Officer Reprogel, who spent more time with Haley Brown than any other individual on the scene for 3 hours, closer and further away, at points in physical contact with Ms. Brown, testified that she was obviously intoxicated and that she had had occasion as a Dixon Police Department officer to encounter intoxicated people under many different circumstances, many different times. So I submit to you that evidence of intoxication is, in fact, scientifically proved beyond a reasonable doubt in this case. And so then I have to go to the defense proof, just briefly. Virtually every single thing, if not every single thing, that those two ladies said on the stand could be true. And it changes none of the facts that I just described for you. None of them. The state of Tennessee is not required to prove that Haley Brown believed she was intoxicated. That is not an element of this offense. If belief that I was too intoxicated to drive was an element of DUI, DUI would barely exist as a crime in the state of Tennessee or in the United States. Because by definition, if I've decided to get behind the wheel, more often than not, I think I'm okay. That can't be the standard, and it's not the standard. It's not something the state is required to prove. Absolutely not. What the state is required to prove is that she actually was intoxicated, as it's defined in the instructions you're about to receive and by the state of Tennessee. That is what we're required to prove beyond a reasonable doubt. Not that somebody thought that she was intoxicated, but that she actually was. And I'll tell you, the reason why one of the reasons why people do not believe that they are intoxicated and make the decision to drive the car is because of the very symptoms my toxicologists explained to you guys, right? The poor decision-making, the inability to perceive accurately. If it was enough that I was misperceiving things to get off the hook, right, then voluntary intoxication would be a defense to everything. You're going to get an instruction in your jury instructions that explains that voluntary intoxication doesn't excuse everything. I need you to pay attention to that as well. Remember, when I talk about these elements, you're going to get an instruction about the law that says absolute certainty of guilt is not demanded by the law to convict of any criminal charge, only moral certainty. And again, moral certainty as to what? As to the elements I'm required to prove, not as to any of this other information that you've heard. The state must prove beyond a reasonable doubt all the elements of the crime charged and that the crime occurred in Dixon County. That's it. The elements of the crime charged, not required to prove anything else. Finally, we heard testimony from a person I have no reason to disbelieve, okay? Miss Sue Connor, that Haley Brown seemed okay to her. Now, I think that's mitigated somewhat by the fact that Jason Brown is much drunker. And you have the ME's report. You can see his BAC. There's no card trick. There's no magic trick here. I don't dispute that. Jason Brown's intoxication at the time of his death is not an element that the state is required to prove. It's not a question that the instructions are asking you guys to answer. But when you read the jury instructions, when the judge reads you the jury instructions, you will discover something about intoxication in the state of Tennessee. The instructions say that it's not necessary that the person be in such a condition as would make her guilty of public
Don't worry about it, Gabby.
drunkenness.
It's fine.
That is not required. The person doesn't have to look drunk. Any condition that deprives one of the clearness of mind and control of oneself, which one would otherwise possess, or If the person has greater than 0.08, 0.08% alcohol concentration in his or her blood or breath, then that person is intoxicated in Tennessee. How bad does the impairment have to be? It has to be bad enough to impact your ability to safely operate a vehicle. If there is anything that was proved in this case, it is that Haley Brown did not have the ability to safely operate the vehicle. The reason why we all know that is because she very clearly did not safely operate it. She operated in such a way that it killed her passenger. So I know her degree of intoxication reached that level. Once again, beyond a reasonable doubt. That's the first count in the indictment. The second count in the indictment is vehicular homicide by reckless conduct. In order to prove that, the state has to prove that she operated a vehicle in such a way as that it killed someone. Once again, I don't think there's any question to that. She has to have been shown to have operated it recklessly. Again, 56, 58 miles an hour in such a way that exceeds her abilities of her vehicle to negotiate the curve, I think, is reckless. I know it's reckless. And by reckless, we mean in such a way as to create a serious risk that it will seriously injure or kill someone. Not only was there a serious risk that her driving of the vehicle would seriously injure or kill someone, it did kill somebody. So we've got that, right? And the recklessness of her operation of the vehicle has to be the thing that caused the death. And again, it's what we call but-for cause. If she hadn't operated the vehicle recklessly, Jason Brown wouldn't have died. That's what has to be proved. And I would submit to you that in addition to her speeding, getting on the road with those substances in her bloodstream is, by definition, a reckless act in the way that recklessness is defined in those instructions. So if you find her guilty of operating the vehicle while intoxicated, knowing that it caused Jason Brown's death, you virtually have to find her guilty of vehicular homicide by reckless conduct. And then finally, the last count in this indictment is simply the count of driving under the influence. Now, one thing that I found juries find confusing and a little bit like disconcerting and upsetting that I found that they've found in the past is when a single event, in this case, a single homicide, leads to 3 separate charges. So I want to touch on that just briefly. First off, the instructions are going to tell you that you're to consider each of the charges separately, one at a time, and go in order. So obviously you want to follow those instructions because that's the law. But if you were to convict her of all 3 of those things, they would merge together into one. It would actually be one conviction. If you were not to convict her of one, but convict her of another, say 2 of them, those 2 would merge. Does that make sense?
So in other words, I think what he was saying there is juries in the past, which good on them, have said they don't like when they throw everything out there, like all the lesser includeds. I hate that too. If you want to charge somebody with first degree unaliving, then prove first degree unaliving. Don't throw second and third in there, involuntary manslaughter, voluntary manslaughter. Don't throw everything out there. What you're charging, prove it. If you can't prove that, then then go to the charge you can prove. I didn't think he overcharged in this case at all. But it did kind of explain why there wasn't negligent homicide or involuntary manslaughter there. Because I think I agree with you guys, those could have been there. So I think he did a good job. He's obviously listened to some jurors, which is good on him. Because I wondered why he didn't have more charges there, because they typically will just be like, well, we can't get this one to stick, then put this one there and put this one there and put this one there and see what happens. I don't like that. Prove what you're going to charge. Thank you, Kathy.
It's been a long couple of days.
Time.
I very much appreciate y'all's time and attention.
Y'all.
And I know that when you consider the evidence that was presented about the elements themselves, the questions that you're being asked to answer, when you consider all the evidence that came from the stand, in particular, the scientific evidence, the crash reconstruction, the blood evidence, that you will be forced to find her guilty of the 3 counts in this indictment beyond a reasonable doubt. Thank you very much.
All righty.
Mr. Pratt?
Just one moment, Your Honor.
Defense has their work cut out for them. Well, we're going to hear video. So question, if they were just charging, if there was no alcohol involved, and I'm not sure about the MJ, if none of that was involved and she was just speeding, do you think they would get her convicted? Because we all speed. Or at least most of us
Morning,
speed.
ladies and gentlemen. Thank you for your time in listening to this case. We both said, General Arnold and I agree, that this is going to be a tough case to hear. These kind of things are always they're always difficult for everybody involved. So we appreciate your time and attention. A few things about what General Arnold just said. First of all, what he's asking you to do, what the state's asking you to do, is look at that .161 number and convict and be done, and we're out of here. Well, and then he gave Officer Bramlage during that testimony, he gave her a variable. Mr. Baker cross-examined her about what variables would be necessary in order to backwards extrapolate, retrograde extrapolate, whatever that was at the time that she was driving. One of those variables very well actually was that there was no drinking. But what he failed to ask her about, or what he failed to tell her about, was that Miss Brown had eaten. They didn't know anything about Miss Brown's experience or fill in any other of those variables. So Special Agent Bramlage, who he describes as his toxicologist, tells you on his facts that he wants to pluck and choose for you that, oh yeah, we can say that she was way over at the time of driving. This is nothing more than a math problem that they just want you to guess at. And you have evidence and you have exhibits, and when you go back there, you'll be able to review those exhibits. And I would like to direct you, if you can, it's at your disposal for when you deliberate. Look at the report. Look at the report that shows the .161. That report sitting by itself right below that .161, which is blown up in big font for you to look at, because that's good stuff for everybody to look at. That's what the state wants you to look at. Right below it, right when it was taken, it says the above amount is the average of 2 tests plus or minus 0.008 grams percentage. That tells you right there that that number sitting there by itself could have been a 0.0153 or 0.169. So this is not an accurate test. It tells you it's not accurate. It's 99.73% confidence level that it's 99.73% confident that it's potentially plus or minus 0.008 wrong. And it's given by a state paid toxicologist in order to make you bite on a number and convict somebody. But But that's not the end all be all here. Whether you find that Miss Brown was over that limit or not, for you to convict her of vehicular homicide by intoxication, the state has to prove beyond a reasonable doubt the three elements that General Arnold told you, and Judge Wolf will instruct you on those. They have to prove that the defendant killed the alleged victim, Jason Brown. And he's right, that's not in dispute. That's not in dispute. And nobody's asking you to make your decision based on sympathy or anything like that. You watch tapes, you've seen the evidence, and it's a tough case, as I've talked about. That the defendant acted recklessly. Well, she said she was unfamiliar with Walnut Street and that curve. She said she was speeding. She doesn't know why she was speeding. But one thing's probably not in dispute. Major Christian's testimony, that vehicle was speeding. But you heard from Miss Brown, she speeds a fair amount. But what I want you to focus on, and what I'm asking you to focus on, is that the killing of Mr. Brown was the proximate result of the driver's intoxication. So separate the fact that there could be intoxication. You can find intoxication. What you have to find beyond all reasonable doubt, moral certainty, and Judge Wolf will instruct you as to moral certainty and reasonable doubt. And we talked about that in voir dire. Not only that she has to be intoxicated, but that intoxication caused the speed, the reckless conduct, and the death. Well, you heard from Dr. McLean, the medical examiner. Mr. Baker cross-examined him about that. And if you'll recall, Mr. Baker asked him specifically, could somebody have a 0.161 blood alcohol count and still not have lost motor function? And he said, yeah, it's possible. So if there's no loss of motor function, if that's possible, then what has the state put up to prove to you that the alcohol caused the speed? In fact, what the state put up was just the opposite of that. Now, Major Christian and Sergeant Summerhour, they were more than fair with Miss Brown in her interview. She cooperated. She came in, and he said, and you heard him say this, speed is a factor. I can't tell you what caused the speed. And that's the crux of this case. That is the absolute crux of this case. They cannot tell you exactly what the number was because they didn't have all the variables. And on cross-examination, they wanted to plug in the variables that supported their theory. But we cannot say, based on testimony, based on the science, that any level of intoxication caused the speed that caused the wreck, which caused the death. We know that Miss Brown, we heard from Miss Brown. She testified, and she has some memory loss. And Major Christian encouraged her to go to grief counseling, which she did. And she, for the first time today, could tell you exactly how many days she had known Jason Brown. And working through those issues and looking through some of those things that she was, and this is in Major Christian's words and Sergeant Summerhour's words, that she was upfront, honest, cooperative, and truthful with them. And she, in studying some of the things that she had mentioned to them, she recalled that there was an altercation, or that there was at least some friction between her and Jason that night. Now, she didn't get up here and try to tell you that some crazy event happened in the middle of the car. She didn't try to make anything like that up and try to convince any of you of that. If she was going to go all in and say some self-serving stuff like that, you probably would have heard her say that he jerked the steering wheel or something like that. She didn't come up here and tell you anything like that. She just told you what she remembered. Now, looking back at the proof of her saying, the proof of her demeanor, her appearance, her confusion on the scene. First of all, I'd like to go back and address Sergeant Chandler's, and not to harp on Sergeant Chandler, but this was chaotic. The whole scene was chaotic, even for Sergeant Chandler. So nobody's trying to insinuate that Sergeant Chandler actually intentionally made up what Miss Brown said to him when he first encountered her. But he was at best confused. So nobody's trying to insinuate that Sergeant Chandler was drinking or that he had lost it. He was confused. This was a highly tense situation. And that got translated from one officer talking to Miss Brown and then talking to another officer and to another officer and to another officer. And before you got it, there's a completely false pretense for probable cause. Now, smelling the alcohol is enough to, that's fine. But it's an example of somebody being confused on the scene that we know wasn't drinking because of the intensity of this situation. So, and General Arnold mentioned that Officer Reprogel did spend a more than fair amount of time with Haley that night. And she interacted with Haley for 5 minutes from 8:16 p.m. until 8:21 p.m. At which time she was 10 feet away from Haley in the back of an ambulance. And she makes a determination that Haley is clearly intoxicated when that's not what her training and experience tells her to do. There's 2 people between her and Haley Brown when she makes that determination. And then she leaves that ambulance. Haley goes from one ambulance, which we believe was the one that Mr. Brown was ultimately, his body was ultimately loaded into that ambulance. Miss Brown leaves that ambulance, and you can see on the video, I mean, the fire and rescue first responders that were out there, they were holding her hand to help her up and down and out of the ambulance. But she didn't have her arm around anybody stumbling or anything like that. It was a step up. You can watch that. That's in evidence. All that's in evidence for you to look at. Now, once she steps out of that first interaction, then what you have is some firefighter, somebody in that ambulance breaks medical protocol and tells Haley Brown, and this is not to garner any sort of sympathy with you or anything like that, but the state is trying to offer her behavior up to you as substantive proof that she was intoxicated. Somebody broke medical protocol and told her that he was dead and sent her into a fit, a suicidal fit, which is completely inconsistent with Miss Melinda Sue Connor's testimony up here this morning, who had seen her at 7:45. Had also seen Jason Brown at 7:45 and was taking Jason Brown's keys and suggesting that Miss Haley Brown drive. That's completely inconsistent with that. So you have Officer Reprogel offering an opinion that she's not going to base on objective science. They're going to get that later. If she wanted that and she knew how to do it, She knew how to do it. Maybe it was chaotic. It was chaotic, and we talked about that during the jury selection. We talked about that it's chaotic in the ER on a Friday night, probably any Friday night. But, and you can go back and watch this video as well. 48 minutes after that wreck, Miss Brown's is in a hospital room with a tourniquet on there. There's blood being drawn from there. If you were investigating, if you were trying to investigate that, whether you'd done the horizontal gaze nystagmus or the 9-step walk and turn, let's just assume that this was not a situation where Sergeant Reproval could have done that. It might have been a good idea to take a look at the fact that there may have been some evidence there. Because one of the other variables that General Arnold forgot to mention to Agent Bramlage when she was testifying about this magic number that they want you to buy is the existence of a second sample. She said it. The existence of the second sample, what Miss Brown ate. There are all sorts of other variables. He only gave her one, and that was the fact that there was no drinking for a certain amount of time. That's not the only variable. Now, okay, now we're back and we're at the hospital. Sometime after, and it was around 8:29 p.m. And that's in evidence. That video's in evidence. You can review it if you want to. Right around 8:29 p.m., and I apologize, I go from military time to regular time. I hope everybody can convert. But at 8:29 p.m., almost on the dot, that is when she is set off by that. She's on the phone, hearing who knows what. And you heard Miss Brown. I'd like you to, Miss Brown testified that she was repeating what people were saying to her. The video will confirm that. You were drinking. Yes, I was drinking. You're in Dixon. Yes, I'm in Dixon. You can watch her repeating back what people are saying to her. You can see that over and over again. So who knows what was said to her on that phone? But here's what we do know. She became confused and thought that her dad was dead. We don't know why or how, but we do know that she was pondering a traumatic event where he had tried to commit suicide. And this is not something that she's come in here and made up. If she was going to do that, again, she would have come in here and said, hey, he jerked the wheel. It wasn't my fault. She's not doing that. She's here to tell you the truth. She's here to tell you her truth about what happened. And you've heard from her. So between 8:29 p.m. and 8:47 p.m., sometime around 8:47 p.m., this is 18 minutes after she's been set off. And that's when the blood draw occurs that we never find. No dispute that that could be the best evidence of whether or not her BAC was. That would be the best evidence of what her actual blood alcohol count was. And we didn't get it. And I'm not saying whose fault that is. The hospital told Sergeant Summerer they didn't have it. It wasn't looked at. It wasn't followed. Instead, what did Corporal Reproval do? Instead of advising the medical personnel on the scene, or I'm sorry, at the hospital, that a first responder on the scene had set her off, she took it on herself to try to set her straight, which set her off again immediately. And then she breaks into just these blood curdling screams, and she goes suicidal right there in the hospital. So as far as this being proof of intoxication, you heard from the doctor. You heard from the attending physician. And I'm going to play that for you real quick.
Okay, just so you're clear, EMS told her about the dress, okay? So I told her it was not her dad, it was her boyfriend.
Horrible.
Well, this guy,
Sorry.
he's like, oh, we don't tell people not to look for dying in an emergency, there's blah, blah, blah. I was like, EMS already told her. He's like, okay, and they shouldn't have done that. I was like, okay, well. Yeah, I was like, I don't work here, how am I supposed to know your rules? And he's like, well, you don't do.
I don't know if you guys can understand that or not. I cannot, but the closed captioning is actually picking it up quite nicely this time. This is Officer Sassy Pants when she got in trouble with the ER doctor, the head ER doctor, and she's all pissy about it. I don't know why he's playing this. Oh yeah, she's, I think, defending herself to her captain. But I can't understand it. It's him holding the mic up to it, so I would love to fix it for you if I could.
That was wrong. I was like, okay, anything else? He's like, no, and he just turned it off, and that's why he came in there like that. Goodness. And I agree, he and I shouldn't have said anything, but they did, and she knows someone's dead. And she thought it was her dad. And she was screaming. So like, yeah, I was like, you didn't tell your dad. I mean.
So like I was telling her, we don't confirm a local staff in the house. I don't know which one of your partners told her, I don't know who of your coworkers told her, but her boyfriend is dead. Her husband and whoever is dead before
It
you.
was EMS worker.
Yeah. Okay. Whoever they did this stuff, we don't say if your boyfriend's dead and you're more invested. We don't.
Okay, well, like I said, she was aware of that when she came in here.
I'm aware. I
Okay,
saw her when she came in.
okay, then I don't,
No, stop talking.
no, I'm not gonna stop talking.
Forgot that part.
It doesn't work like that.
It does, this is my witness.
Okay,
I'm gonna stop, I'm gonna finish.
okay, you can finish.
Do not confirm that, because people don't know what's going on. When there's a lot going on after a car crash, or somebody died, and they're already freaking out, and they potentially need an exam, you don't go in and confirm somebody's dead when they're already emotionally distressed. You let us, it's our job, do that. You can
Okay,
do your investigation, but don't confirm that, that is our job. She's now still distressed, and I cannot get her to agree to an exam, and she's not in a right mental state of mind where I can comfortable discharge her and prove her. Because of that.
okay, good.
You hear the doctor say she's not in the right mental state of mind because of the distress. That's a medical opinion right there as to what was going on. Which would explain totally the difference in her demeanor from the time Melinda Sue Connor saw her until the time she gets into that emergency room. There's a medical opinion right there telling you that. Now, in General Arnold talked to you quite a bit
I was wondering, Adair.
about the instructions that Judge Wolf is going to give you there. And I want to, well, and I apologize. Later on, Sergeant Summerhour comes in. Sergeant Summerhour comes in around the time that Miss Brown's mother had arrived. Well, you heard testimony from the initial witnesses that were on scene. She's grasping for anybody that she can grasp for. She's frantic. She's panicked. All she wanted was her mom. She's screaming. She's suicidal. And right before Sergeant Summerhour comes in and she cooperates. Who's there? Her mom. All she wanted was for somebody to console her. She was cooperative. They said she was cooperative. Cooperative at the interview, signed the implied consent form, gave them the blood willingly. But again, and going back to the instructions, you have to show that her intoxication was the proximate result that caused Jason Brown's death. Again, you can do the math if you want to. You can buy the math problem. You can look at it and see that there's errors on the face of it. You can see that there were variables missing in the testimony given by Agent Bramlage. You can see that, but you can do all that, and then you can still turn around and find that she was above a .08 at the time she was driving. You can do that if you want to, but you still have to take that intoxication and attribute that's it. Beyond a reasonable doubt that intoxication caused his death. It can be there, but it still has to be beyond a reasonable doubt that it caused the death. And you'll get that instruction. And the only expert testimony that we've got as to what caused that death, the only scientific, credible testimony would be Major Christian telling you that speed caused that accident. And I would submit to you that speed had nothing to do, based on her recollection of the events, based on Melinda Sue Connor's interaction with her, based on what you see has been offered to you as proof of her intoxication, was poorly mishandled scientific investigation of DUI, and then a broken medical protocol that sent her into a state of shock to the point to where she couldn't even be discharged by her own doctor. So if that's reasonable, if that's beyond a reasonable doubt to let the mind rest easily, I just don't see that.
I wouldn't
Now,
either.
with respect to the reckless conduct, again, we can't dispute that credibility of him. I mean, the speed is what it is. That's science, and that was science that had hard numbers. Hard numbers. No variables we could plug in there. So nobody's asking you to make a verdict. Nobody's asking you to feel sorry for Haley Brown. I'm not standing up here asking you to do that. Haley Brown feels sorry for herself, and I'm sure she will, but I'm not asking you to do that. What I'm asking you to do is apply the facts to the law and come to the determination that she's not guilty of vehicular homicide by intoxication, as that is not the proximate cause of this accident. I thank you for your time.
Mr. Arnold?
The cop didn't help things with her attitude. She was awful.
I just want to address a couple of things that he said. By a couple, I mean more than two. Sorry. So he says that I plucked one of the possible variables out to feed to Special Agent Forensic Scientist April Bramlage. The variable he's talking about is how long Miss Brown went without drinking. And he's right. I did give that variable to my expert, who was able to use that variable to give you more information about Miss Brown's VAC level at the time of the wreck. Here's why I grabbed that variable. We know that 100%. that from 8 to 10:48, she didn't consume alcohol. The reason why I picked that variable is because that's more than beyond a reasonable doubt. That's absolute certainty. Because we've got an officer sitting on her that entire time with body camera on. So I didn't just pluck it out over all the variables I could have talked about. I picked it because it's the thing we have the most certain knowledge of. And so it was the most informative for the expert to be able to use. Now, and I don't think math is magic. I actually think we can rely on math. I think that 16 is twice 8 is something that you guys can take back there, and it's absolutely beyond a reasonable doubt. The idea that to make it sound like some kind of hocus pocus just blows my mind, okay? So 16 is twice 8, I'm gonna suggest that's not in dispute. 3 hours of not drinking, I'm gonna suggest to you that after, especially the defense witnesses, that's not in dispute. So the reason why those things were selected is because they are rock solid absolute proof. Okay. Now I want to address proximate cause because it's confusing. It's difficult. People have a hard time with it sometimes. Okay. So
Thanks, Gabby.
what I'm required to prove is that except for Haley Brown's intoxication, we wouldn't be here today, right? This wouldn't have happened. Jason Brown wouldn't have been killed. I am not required to prove that there are no other things that had to happen for him to be killed. Everything that happens to you, to me, to anyone from one day to the next has more than one proximate or but-for cause. If my alarm didn't go off this morning, I wouldn't be here. I also wouldn't be here if I got run over by a bus. So for him to suggest that because Miss Brown's fast driving is one of the things that caused the wreck, and that means that her alcohol intoxication isn't also a cause, is a mistake. It is a confusion. It can be true that but for her going 58 and a 30, he'd be alive today. And be true that but for her being intoxicated on alcohol and marijuana, he'd be alive today. I'm only required to prove the second thing. In reality, I think the case proves both things. I think the intoxication is the absolute best explanation for not only the speed.
Counsel's opinion.
Saying counsel can argue the facts to you, but cannot give you his personal opinion. So Mr. Arnold, refrain from your personal opinion. The jury will disregard that.
Whew, that's
rephrase
like
that.
one of the few the judge gave him.
The proof in the case has given us a very good explanation for the way that vehicle was being driven, in the form of symptoms of intoxication and what those symptoms do for driving. They cause distance and time perception problems, motor coordination problems, problems with perceiving speed, problems with decision-making. Driving faster than you ought to drive, than a person ought to drive, is an example of a poor decision. Our toxicologists explain that intoxication causes poor decisions or can cause poor decisions. So the point is that the proof shows that speed is a but-for cause and that intoxication is a but-for cause. And just because one of them, speed and recklessness, is a but-for cause of colliding with the pole, doesn't mean that intoxication doesn't also play a necessary role.
I don't know. I was singing Big Ben.
This kind of causation, you can have more than one. The state is only required to prove that intoxication is among them. That is all I'm trying to say. Now, in terms of a lot of this, It's not one of the elements I have to prove that Miss Brown was not upfront, honest, cooperative, and truthful. That's not an element of this offense. It's not an element of this offense that I prove that there wasn't an event that caused friction between her and Jason Brown that night. That's not an element of this offense. Those are entirely red herrings. It is not an element of this offense that I prove that Sergeant Chandler wasn't confused at some point about what was or was not told to him by Haley Brown. Though I think it's pretty interesting that the thing that the defense was so upset about, him ultimately saying to Sergeant Summerhour, namely that she'd had 3 drinks, turns out to be exactly what she tells Sergeant Summerhour and Captain Christian in an interview 3 weeks later, which lends a little bit of credence to Sergeant Chandler's redirect response that a lot of people were providing him information on the scene.
So there's no objection. Those facts are not in evidence that Sergeant Chandler ever got that information, and that was ever linked up.
Ladies and gentlemen, you are the triers of fact. Therefore, you will recall the testimony. The argument that Mr. Spratt makes is that wasn't what the testimony is, and I'm going to overrule the objection because that basically lies with you as the triers of fact to remember what the testimony was.
It is not an element that the state is required to prove that the Dixon Police Department did everything perfectly. That's not an element of this defense. But I would like to come to the Dixon Police Department's defense in this instance. The suggestion that Officer Reprogel should have pulled Miss Brown out of that room and run her through field sobriety tests when she couldn't get permission to speak to Miss Brown about what had happened that night and drew that kind of fire from the ER crew based on that it defies belief. It's just not fair. It isn't fair.
Oh,
And I just want to point out.
No, you can't defend her. She broke protocol. She did it wrong, period. Nobody said to drag her out of that room and do field sobriety test on her. He was talking about why didn't they not do them at the scene? Should they have done them at the scene? No. They just couldn't do them in this situation, period. They just couldn't. It wasn't appropriate. But neither is what she did. So please don't defend her. The officer screwed up and she couldn't even admit, I screwed up. It would have just looked better. It didn't really affect anything other than just her attitude was bad, which make me kind of question her in general. What kind of person are you? Just say, I'm screwed up. Tell the doctor you're sorry. But you didn't. You doubled down. So the fact that he's going to defend her now is probably going to just piss me off and irritate me to no end. Just take his little egghead and crack it.
That's not fair to the Dixon Police Department.
Figuratively
When I
speaking.
redirected her, you guys heard her explain tests. When she couldn't get permission to speak to Miss Brown about what had happened that night and drew that kind of fire from the ER crew based on that it defies belief. It's just not fair. It isn't fair. And I just want to point out that that's not fair to the Dixon Police Department. When I redirected her, you guys heard her explain that we allow doctors to complete their treatment before we start doing certain kinds of investigation. So it's not our job to jump in and start taking things from them, pulling people out of.
Was she discharged? No, because the doctor said, is she under arrest or not? He asked her that point blank, and she couldn't answer. And then he said, I can't discharge her now because I can't examine her because of your big mouth. He's so wrong right now. And he's not telling it how it happened. Sorry. I'm sorry. I hate when this happens. It drives me nuts. Just tell the facts as they are.
Rooms until medical personnel are finished. I don't have to prove that Dr. Lippert was wrong when he said Haley Brown was emotionally distressed. That's not an element of this offense. Not only do I not have to, I don't dispute it. Obviously, you all saw with your own eyes that she was emotionally distressed. It's not an element of this offense to prove that Haley Brown didn't want to speak to her mom. It's not an element of this offense to prove that Haley Brown was not suicidal. It is not an element of this offense that I'm required to prove that she was not distressed. Those are all exactly the kinds of things that I was speaking to you guys about in voir dire when I picked this jury, when I was explaining that there are going to be things you're instructed that the state is required to prove beyond a reasonable doubt and things that we're not required to prove. And an enormous percentage of what was just said in that closing argument touch on things that the state is not required to make any proof about. Thank you guys again for your time and attention, and I know you'll do the right thing.
Judge, may we approach?
Probably.
You want this on the record?
Maybe.
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 Not a yes or a no.
Well, not at the moment.
Not at the moment.
Oh, not only are we approaching, we're leaving. Bye. So I thought both of them were doing fine until his last little bit there. And then he obviously irritated me. One thing I don't agree with the state on is her memory loss. It's being all,
Saying that the argument that they would be merged.
Judge, we can hear you. I can't understand him. We're not supposed to hear that. But I've had less traumatic things happen to me that I don't remember. So I don't agree with him on that point. I know her blood alcohol. I'm not past that either. I'm not trying to say she's innocent. It's just not, I don't know. I don't know. Yes. You did. And I will give them credit too. I just don't agree with everything that he said because I just don't attribute it was traumatic, period. You should have asked him to do that before you stepped back in your office and yeah, I couldn't understand it though.
Well, give them the option. It's 17 pages. So.
Yeah, 17. Don't worry, we won't listen to jury instructions.
Record?
Yeah, and sometimes you don't
Judge,
get
if
it
you
back.
recall in the state's initial closing, the state made a comment to the jury. And that comment was, you're choosing between three charges. If you convict on all three, those charges merge, and Ms. Brown only gets convicted of one charge. That, I submit, is an improper jury argument. To the point, to me, it rises to a mistrial. For this fact, we've now told the jury, it doesn't matter what you do here. You got three charges to choose from. You can convict her of all three, and she only gets one conviction. I don't know how you unring that bell, because that runs counter to what the jury charge is. The jury charge is you're to consider each three charges individually as individual counts. Well, the state has effectively now planted in the jury's head, well, it don't matter what I do, she only gets one conviction. So if we're going to convict on one, we convict on all three, and it doesn't matter. Because that is logical thinking. A logical person would say, if I convict on one, it doesn't matter if I convict on all three. And that's
Good.
effectively what the state said, and there is no way to fix that because Mr. Arnold has put in the jury's head. Hey, if I'm gonna convict on one, it don't get no worse, whether I pick 1, 2, or 3 at this point. To me, that's a mistrial, Judge. That can't be fixed. Or in the alternative, I guess we have to craft, or I would craft some type of jury instruction, because natural thinking to any person, hey man, if you're gonna convict on one, it doesn't matter. It's the same as 1, 2, or 3. But what would any rational person say at that point? Well, if we pick one and you're guilty, it doesn't matter at that point beyond that.
Arnold?
And I think he did till just what he just brought up and just this very end. I think the state played by the rules.
Judge, the comment that I made in my closing that he's describing, I immediately followed up with, you are to consider each of them separately. The only import or meaning of the comment was, I did not want the jurors to think that a person could kill one person and thereby be convicted of 2 separately treated homicides. As Your Honor knows, as I know, having filled out judgments after these cases many, many times where juries have convicted of VH by intoxication and VH by reckless conduct. And then in the third count here, I've charged a lesser included of the first offense. If the jury finds the person guilty of all 3 of those things, all 3 of those things will merge. And not only in these vehicular homicide cases do I have that situation, when I charge alternate theories in DUI cases, when I charge the per se and the regular count, I've had jurors come back repeatedly and say, hey, that's confusing. How can somebody commit 1 DUI and be guilty of 2? And I've actually, I think an instruction would be sufficient, Judge. I don't know that it's required. I've mentioned merger in closing arguments. I actually do not know how many times. So, I mean, if it's inappropriate and it needs an instruction, then by all means, I'll stop doing it. But I've not ever had it objected to before, but I don't think
Like me.
I don't think it causes mistrial, Judge.
Judge, if I could briefly, for the record, I would like you to think of it in this terms. I mean, we're talking about normal people. If you go to the grocery store and it's buy one, get 2 free, you don't go in and say, only give me 2. So
On page 15 of the final instructions, of which both sides have been given a copy, the following instruction is given to the jury and will be read to the jury, and they'll have their own individual copy. The defendant is charged in 3 separate counts of the indictment. Although these cases are being tried together, they are separate and distinct cases. You must decide each case separately on the law and evidence applicable to it, just as though each case is being tried separately. You will be asked to render a verdict as to each count of the indictment. The defendant may be found guilty or not guilty on any or all of the offenses charged. Your findings as to each crime charged must be stated in your verdict. That clearly and sufficiently, in my opinion, is a charge that defines for the jury their role and how they're to do it. Your objection is to an argument that was made in the first part of his argument. There was no contemporaneous objection made at that time. My proposal and my decision is that I will craft one short instruction over the lunch hour that basically says to the jury that I have previously instructed you that arguments of counsel are not evidence. Statement of the district attorney regarding the merger of any of the counts of this indictment is not evidence, and you are instructed to follow the laws that I give to you in the final set of instructions. And I'm going to read that to him before I begin the final charge. Your motion for a mistrial is respectfully denied. We will proceed with that one instruction, and I'm going to bring the jury in and send them to lunch so that we can get that done.
Because if anybody's feeling like we're feeling,
And in the future, Mr. Arnold, I would suggest you not make that argument.
Apparently, Judge, sorry.
oh, I'm going to allow it this time, but don't do it.
The final instructions are what should be argued about those kinds of things, rather than.
So he did kind of admonish him, don't do that anymore. I mean, he probably shouldn't. He's not. He's not. Not for
Anybody
black.
hungry? I am. We're gonna let you go to lunch. I am going to give you a specific instruction during your absence from the courtroom. I considered an issue, and I've previously told you that the arguments that lawyers make to you, both in their opening and their closing, are not evidence, and they are not stating to you what the law is. I'm going to read you 17 pages of instructions on the law, and you'll get your own copy. That is the law, not what the lawyers make in their statements to you and arguments to you. There was something that was stated to you about a merger, and I'm going to give you a specific written instruction supplemental to what I'm going to read to you here, that you're not to consider that, not to consider what was said about merging those things, because that is my responsibility, how I treat those things, not the jury's responsibility. You're going to be instructed in these final instructions and in the written instructions I give you
Fine.
that you are to consider each count of the indictment separately as though they were being tried separately, even though they're being tried together. So I'm instructing you right now to disregard anything that the state may have said about merger. Put that out of your mind. I'm going to give you a specific written instruction when we come back from lunch and tell you that in addition to the instructions I give you in writing. So with that, we will be at lunch until 1:15, and that'll give you a few minutes extra and me a few minutes extra to get this done. But at 1:15, we'll ask you to be back in the jury room, and I will then give you the final charge, and you'll be allowed to retire to deliberate. Now, I would remind you that we have two alternates, and
Well, it is
luckily we have
10.
not had to use those alternates yet to fill in for somebody who had to leave. But when we read that final charge to you at the end of that time, I will select randomly two of your numbers that will be discharged, and you won't have to decide the case. You can stay and talk to the lawyers and let them know what your thoughts were, or you can leave and vamoose, so to speak, whatever you want to do. But under the circumstances, that will happen after I've read the final instructions. So we'll let you go to lunch until 1:15, and then we will see you back in the jury room at that time. We'll stand in recess until 1:15.
All rise. This court's now in recess until 1:15.
Or I forgot which one I was on. Or until we just slide on down. Yeah, Stormy, did your son come out wearing blue suede shoes? Gabby. Only you. All right, I got it. For some reason, I have a time stamp here, and then we'll go past the jury instructions. 17 pages. 17 pages.
I've prepared a preliminary instruction to the final charge of the court, and I'm going to read it to the jury when they come back in response to that situation that was raised. Anything else?
No response other than our objection, Your Honor, but I do have one matter before the jury comes back, if I may. Just real short. General Arnold and I made some notes as to what times in the military time were played for the jury, and so we want to just file that.
That's fine. You can file that so that in the event that they want to review any of those texts will know which time frames they are.
Thank you, Judge.
Take the record.
I was like, what?
Right, and we're, they're gonna get this original. I'm not gonna give them each an individual copies. We do have original, you have the chart of it. We're ready.
Well, I don't. Thank you. I've never been on a jury. I'm just going by what I see. But I do think Felicia's right, because that state guy said he's heard from other juries how confusing that would be. And then he muddied the water. He was like, here, I'm going to make this really clear. Didn't overcharge him. Great. Now let me pour some dirt in here and stir it up. They were on, we just heard closing arguments, Hamilton. Jury was at lunch. She has 3 counts against her, and the state was like, if you convict her of all 3, it's don't worry, they all merge into one, and if you convict her of 2 but find her not guilty of 1, don't worry, those 2 will merge. It just muddied the waters a little bit, and the defense didn't like that and asked for an instruction. Actually asked for a mistrial. Judge denied that, and then asked for a jury instruction on that. And then the judge agreed to the jury instruction and then told the state, don't make that argument again. So that's really all that's going on. We're going to I forget what's going to happen right here. I don't know what's going to happen, but I have a timestamp here. So we're going to see. I have watched a lot of trials. It is, because this is what's happening every day to all of us, every day. Could be any of us sitting there. And even if you don't think it can be you sitting there, it can be you sitting there. I just wish people understood that. That would have been pretty cool. Not to be on the trial, but to sit afterwards. Oh, yeah. They aren't over in 45 minutes. There's no commercial breaks. Half the stuff you see on CSI is crap. Half the stuff you see on TV lawyers can actually do. There's a lot. That's why I like when there's a verdict watch on like court TV and Law and Crimes Chat. They're like, did the jury say what time they would be back? No, they didn't. First trial. Okay. See what's happening here with the jury. Yeah, if they weren't so expensive, and the transcripts you can read them, but transcripts are very, very expensive.
Ladies and gentlemen, I'm going to give you an initial instruction that's not included in that. So if you'll bear with me while I do that after everybody gets to just wait to start reading on that copy you're being given until I finish with what I'm about to do.
Gabby, I've been there. That's why I'm here.
This will be the preliminary jury instruction on the preliminary to the final charge. Ladies and gentlemen of the jury, it is the job of this court to instruct you on the law, and that law assist you on how to proceed during deliberations in reaching a verdict. In addition to the final charge that will provide you with the elements of each count that the state must have proven, This preliminary instruction is given to you based upon comments made by the state during closing arguments. As I stated before, comments made by attorneys are not evidence, and I am instructing you to disregard any statement made about merging counts and instead follow my final instructions, which instruct you to consider each count separately and to determine guilt or innocence as to each count as though they were being tried separately. You may not allow anything but the law and the evidence to have any influence upon your verdict. The defendant is charged in 3 separate counts of the indictment. Although these cases are being tried together, they are separate and distinct cases. You must decide each case separately on the law and evidence applicable to it, just as though each case was being tried separately. You will be asked to render a verdict as to each count of the indictment. And I'll now read the final instructions that will assist you in reaching a verdict. And if you'll read along with me, the defendant.
All right, unless I know that the majority of the people here do not want to listen to 17 pages of jury instructions, so we're going to slide on. I think I came up to where he picks the
Now
alternate.
select.
And yes, Gabby, they just go pick meeny, miny, mo. I heard this one's bad. I heard this one's not. So this one. Well, I'm glad that he's been in prison, Felicia, because it sounds like that's where he needed to be.
Number 69, Christopher Wall.
Gabby, you lie. I can't believe they
Well,
say the name.
you have anything back in the jury room? If you'll step back there in a moment, the officer, step into the hallway, and Officer Howell will assist you in recovering whatever you have, and you can turn in your jury bed.
You lie. I can't believe they said
And
the
number
name.
17, Roger Carter.
Well, Roger, and
All right, same with you. If you'll go into the hallway, they'll assist you with that.
I'm with you. This is why I
Ladies and
don't.
gentlemen, because they are now discharged, we need to wait and let them clear out before you go back to begin deliberating, so there can't be any interference or any outside person other than the 12 of you who will decide this case.
Judge, may I hand these to the bailiff?
Yes. What is it?
They're excuses, work excuses.
Oh, okay, yes.
Yes, it definitely sounds like that's not a person that needs to be out ever.
Thank you.
That's quite the door. Thank you.
As soon as they can confirm that those 2 individuals are out, then we can let the jury go back.
All right, so we know the names of the 2 jurors that were not chosen. Why give them a number if you're going to say not only their number, but their name? Why? Okay, so looks like the jury goes back at, we'll just say 4:53 on the counter here to start deliberations. But still, I didn't catch the first guy's name, so maybe that's what they're counting on. And obviously, the state knew the last defense witness, and the defense, I think he knew her. Yes, you guys are all right. Again, that would be my town. You'd be like, who called off today? Who wasn't here? Okay, so we go. So they start deliberating. We'll just say 4:53. Somebody's gonna have to do math because I don't. I don't math. When the state was like, it's math. You can't beat. I'm like, 16 is double of 8. I'm like, well, have you seen today's math? Because you can answer whatever you want it to be. This is she said she had family, but she said 20 hours, but I think she meant she hadn't seen them in 20 years.
I've been handed a note that the jurors have submitted, and it says, what is the legal definition of reckless driving as it relates to speed, parentheses, miles, mph, miles per hour? That is the question that they have asked. So, either side wish to address that? Pardon?
I can address one issue. I know.
Well, let's hear from the state first, since they have the burden of proof, and then I'll let you hear.
Judge, I believe that the legal definition of unfortunately reckless driving is actually in the jury instruction.
I think it
So
is too.
I think all we can do is refer them to that page, unless I'm mistaken.
Yeah, I'm of the opinion.
Anyway, I don't have my copy, and they took my copy of the final charge back with them. Do you have your copy?
I do, Judge.
Mr. Baker, you have something?
I do, Judge, and I can, if you'd like to take a brief recess, I can get you the case law on it. It's our appellate courts have repeatedly held speed alone is not reckless driving. You have to have something additional to that, but I don't know that we can give any additional information to the jury on that. So I'm like the general, I don't know. It would probably be helpful to give that to them, but I don't know that we could give that to them at this point, since they've already been charged and we give them a definition.
And Judge, his mom just died, so he's still working. Be nice to him. Well, I could probably tell him to be like, "Hey, Gabby's gonna show up. Meet me up there today," and he'd be, "I thought you
Well,
were
the definition of reckless driving and the instructions on the law on reckless driving are given on page 12 of these instructions. And basically, at that point, it states the legal definition of, or the elements that are required to be proven. It also defines to constitute willful disregard for the safety of person. It doesn't mention speed, but it does clearly define that the offense of reckless driving according to statute. And I tend to agree that with both counsel and Mr. Baker is correct that to go outside of that, it would seem to me to be inappropriate to try to give them an additional definition of reckless driving that includes some sort of element of speed. So I am of the opinion that the only thing I can do is tell them, bring them back in and tell them that the definition of reckless driving that the law permits is set forth in there instructions and that those are the instructions they must follow. So is there anything, I don't see the need to submit that in an additional written form. I'm just inclined to point that out to them on page 12 of these instructions. Anything else?
No, Judge, I think that's right.
Bring the jury in.
Get them in here. I wish they would not slam that door.
Got one in the restaurant, Judge.
It's the little lawyer's room. Deputy's like, I would never say that. You suppose they've had time to, well, they have had time. Do you suppose they painted that horrible courtroom down in Key West? Yes. Page 12, paragraph 2, second sentence, 2 sentences in. Because this courtroom looks so clean and fresh. That courtroom down there, it's like, did we time travel backwards into 1970? Well, that courtroom is horrible, Stormy.
Ladies and gentlemen, I've been handed a question that's been submitted by one of your number. It says, what is the legal definition of reckless driving as it relates to speed, parentheses, miles per hour? Ladies and gentlemen, I have given you the legal definition, the only definition of reckless driving that the law allows. And that is set forth on page 12 of those final instructions. And that is for you to, and it sets forth the elements of reckless driving as well as what constitutes those elements or the definition the law gives. And that is that any person who commits the offense of reckless driving is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant drove a vehicle in willful or wanton disregard for the safety of persons or property. To constitute willful disregard for the safety of persons or property, there must be a design purpose, an intent to do the wrong, while to constitute wanton disregard, the property doing the act or failure to act must be conscious of his conduct, and though having no intent to injure, must be conscious from his knowledge of surrounding circumstances and existing conduct that his conduct may naturally or probably result in injury. That's the legal definition of reckless driving. There is no other definition having to do with speed, and that is the definition that you must apply in this case. I hope that has answered your question, and will allow you to return and begin deliberations again. We will again stand in recess pending the return of the jury. So. Carl, I'll give you back your copy of the charge. I have my copy is the final charge draft number 1, which we made a couple of changes to. So I'll give you that.
Office. All right, what did I tell you they started deliberating at? 4:52? So it looks like they deliberated for about 3 hours. All right, Ronnie. We're getting ready to hear the verdict. I don't know if we will be here, but if we are, come back in.
And receive the verdict.
I just wanted to, yeah, they're coming, the jury's coming in.
We have everyone back. Ladies and gentlemen, I'm told that you've been able to reach a verdict. If you have, well, I guess we haven't got everybody back. So.
Oh, sorry, Ronnie. Somebody must still be in the bathroom.
All right, let me try this again. Ladies and gentlemen, if
There we
I
go.
understand correctly, you've been able to reach a verdict. Is that correct? All right, would the foreman or forelady please stand? As to count one of the indictment on the charge of vehicular homicide by intoxication, how does the jury find? Not guilty or guilty?
We find not guilty.
As to the lesser included offense under count one of driving under the influence, do you find the defendant guilty or not guilty?
Guilty, Your Honor.
Count two of the indictment as to the charge of vehicular homicide by recklessness, how do you find the defendant not guilty or guilty?
Not guilty.
As to the lesser included offense of reckless homicide, how do you find guilty or not guilty?
Not guilty.
As
Ooh,
to the lesser included offense criminally negligent homicide, how do you find not guilty or guilty?
Guilty.
didn't know those were
And
in there.
count three of the indictment as to the charge of driving under the influence, how do you find the jury? How does the jury find the defendant rather guilty or not guilty?
Guilty.
All right, so that if I may make sure that I'm correct about this then, on count one, the defendant has been found guilty by you of the lesser included offense of driving under the influence. On count two, the jury has found the defendant guilty of criminally negligent homicide. And on count three, the jury has found the defendant guilty of driving under the influence. Am I correct? Ladies and gentlemen, is this the unanimous verdict of all of you? If you will, signify by raising your right hand. Let the record reflect that it is the unanimous verdict of the jury. Ladies and gentlemen, I know you've worked hard on this case. Thank you for your attention on the matter and for giving it your time and efforts. We'll talk about whether or not, do we have plenty?
Do you guys want me to back that up? That went really fast. I didn't know all those lesser includeds were in there because he didn't talk about it. So never mind what I said about the state not overcharging. I take it all back. That was very, very fast. And also let me move the closed captionings because they're bugging me. Just like my hair is bugging Gabby, I'm sure. So I'm pretty sure they said not guilty of vehicular homicide, but guilty of DUI. And then guilty of maybe not recklessness, but I don't know. Negligent homicide, I think that's what they got. That's a good point. He was not wearing a seatbelt. I don't know, Ronnie. I'm gonna have to hear what I'm gonna replay that verdict because it was really fast, and then I'll have to hear the end of this because it's almost over, and then if he doesn't sentence her right then, I'll have to go look and see if when her sentencing is. But I didn't wanna know the outcome of this before you guys did. I mean, I can sludge. I can slow the judge down. I don't have him sped up, but I can slow him down a notch if you guys need me to. I mean, he's on normal speed, but I can back him down one. All right. I just thought he read he read those so fast.
And receive the verdict.
He'd be like, "Girl, please." Well, that would be fun. I just don't think it's gonna happen. You'd be like, "You do one interview, huh?" All right, I'll see if I can write these down.
We have everyone back. Ladies and gentlemen, I'm told that you've been able to reach a verdict.
Stop throwing my
If you
words at
have, well, I guess we haven't got everybody back, so. All right, let me try this again. Ladies and gentlemen, if I understand correctly, you've been able to reach a verdict. Is that correct? All right, would the foreman or forelady please stand? As to count one of the indictment on the charge of vehicular homicide by intoxication, how does the jury find? Not guilty or guilty?
We find not guilty.
As to the lesser included offense under count one of driving under the influence, do you find the defendant guilty or not guilty?
Guilty, Your Honor.
Count two of the indictment as to the charge of vehicular homicide by recklessness, how do you find the defendant not guilty or guilty?
Not guilty.
As to the lesser included offense of reckless homicide, how do you find guilty or not guilty?
Not guilty.
As to the lesser included offense criminally negligent homicide, how do you find not guilty or guilty?
Guilty.
In count three of the indictment as to the charge of driving under the influence, how do you find the jury? How does the jury find the defendant rather guilty or not guilty?
Guilty.
All right, so that if I may make sure that I'm correct about this, then on count one, the defendant has been found guilty by you of the lesser included offense of driving under the influence. On count two, the jury has found the defendant guilty of criminally negligent homicide. And on count three, the jury has found the defendant guilty of driving under the influence. Am I correct? Ladies and gentlemen, is this the unanimous verdict of all of you? If you will, signify by raising your right hand. Let the record reflect that it is the unanimous verdict of the jury. Ladies and gentlemen, I know you've worked hard on this case. Thank you for your attention on the matter and for giving it your time and efforts. We'll talk about whether or not, do we have plenty?
As long as you just keep one in the rest of the 10 years.
We're going to excuse you from any further jury service during this term because you've spent 3 days of your life down here. So I know that was something I promised I probably couldn't do, but I think under the circumstances, 3 days are sufficient. So you will be released from any, well, one of you has been requested to be.
So basically, two DUI charges and one criminal negligent homicide charge. So I don't know what that. I have no idea what that carries. And
Be
we'll see
kept
what
on, but it's not her. So. Ladies and gentlemen, if you will go with Officer Howell, he'll let you get your items and help you be escorted from the road. Thank you for your time.
which I didn't know
All
those were.
right. The jury having found the defendant guilty of 3 different offenses, the court will need to set a sentencing hearing. We'll order a pre-sentence report. We have a criminal docket on in June. Will that be sufficient time?
Yes, Judge, we'll waive the 45 days, Your Honor.
Oh, so she's not even been sentenced yet.
On the 5th on the 5th of June, I show that we have Paul Garrett motions in the child rape case, and then the 6th it carries over. So let's set this for the 6th of June.
Judge, and I apologize. I have a rape trial with Judge Wallace in Waverly that my understanding he isn't going to go. It's fairly old.
Yeah, that's.
All right, what about the 10th of May?
Oh no, I don't know. It is a long time.
I'm good to go for that, Your Honor. 10th of May works for us, Your Honor.
All right, May 10th, day after Ed Montgomery.
I've got it. I've got the 10th open, Judge.
Pardon?
10th of May.
10th of May. I have motions in the State versus Sarah Fuson, which is that Montgomery County case that I've been assigned to hear, but they're here in Charlotte, so we should be able to do them. Let's set the sentencing for 9 o'clock, and then we'll go from there. All right. We'll conclude our business before the court for today, and she will be allowed to be released on bond pending that sentencing hearing. Anything else?
Nothing, Your Honor. Thank you, Judge.
All right, we stand adjourned.
All rise. This court is now adjourned.
Well, what do you guys think? I was shocked and not. I mean, I guess if she didn't have the lesser included in this, I don't know, maybe they would have just found her not guilty, but that would have been hard for me to do because of her blood alcohol content. But well, considering I don't know what the punishment can be for the negligent homicide one, Ronnie. It doesn't surprise me because the other 2 were DUI charges and they're 4 years old at this point. So I'm not sure. I mean, a lot of people are, especially on DUIs. But I think they are, I think they were just trying to maybe as conflicted as we were about things. I don't know. Obviously, because we weren't there in their heads. So I don't know how much time that she has served, if I would assume. Let me go see if I can find anything. I'm sure Gabby's probably already looking her up. I purposely did not look anything up about this trial. I agree, Chrissy. I think this was one where uh I think she had to take the stand, and I think it was good on her to do that. You got all your Southerns, all of them, Gabby? You expect me to believe that? Because I don't believe it. See? I told you. Let's see. YouTube, Haley Brown, Facebook. Gabby, I might need your FBI abilities on this, all of you, because I know women are better than the FBI most of the time. Now I don't even remember. What were we looking for? What did I tell you I was looking for? Oh my goodness. A butterfly. Dang. I have so many things going through my mind right now. Oh, yeah. See, story. I don't know that she has been. My guess is she wasn't. And if this is her first thing, I don't know. Um, all right. Well, I can give you the outline of what she's looking at. First time DUI offender. So, first time DUI offender, 48 hours to 11 months, 29 days. 0.20 BAC or greater, minimum jail time 7 consecutive days. License revoked 1 year, restricted license available. Participate in drug and alcohol treatment program, pay restitution, $350 to $1,500 fine. Ignition interlock device installed at your expense. So I would assume that's her for that. Well, that would go good with Gabby's cold iced tea, which I'm sure is sweet tea. All right. You guys look up jail time. I'll look up uh her what time. So I don't think she's probably gonna get time on that. Looks like 7 days. If it was 0.20 or greater, and it wasn't. Oh my gosh. I said I wouldn't look these things up anymore in case anybody ever had to come and search my phone. I will keep that in mind next time I'm in the South. Let's see. I didn't find anything when I just asked if she'd been in jail. Um, don't care about that. Oh, see you, Stormy. Have a great weekend. We'll be back Monday. I don't know what we'll be doing, but we'll be here. Um, oh, dang it. That's not what I want. My gosh, there's too many variables. I don't know. We shall see. We shall see on May 10th. um, the case he was talking about on why he couldn't do it, I think in June, I didn't listen to it because it sounded horrible and I wasn't sure that how bad it would be. And because I think it was a child grape case, to say it the YouTube friendly way. So I didn't. Yeah. I mean, all your laptops are gonna have to go to the ER on Monday. I'm just saying. Laptop ER. Gabby. Is it soda or pop? I don't know. I don't know. Felicia, did you find the name of the trial you said is starting on the 3rd? Oh, I need to look at that other trial. Chrissy, when's your trial start? Is it Monday by chance? Oh my gosh. Jose Ruiz, whatever, notes. So he could make your stuff not work. Let's see, 8:30 your time to just whenever we get done, right? Sorry, Gabby. My hair's been behaving until I put myself on the big screen. Okay. I watched Judge Boyd yesterday's. Today, yeah. She looked good. She was joking. Oh, well, good for her. Yikes. All right. I'll still look at it. Uh, but just so you know, Judge Boyd looks good. She was joking about movies and why they just keep making remakes of stuff. And I was agreeing with her. Yeah, I'll look at it for sure, Christy. For sure. I've lost my page. I, I made a note to myself to get a notebook that has dividers in it. I keep seeing all this stuff like, see you, Ronnie. Glad we could get that verdict to you before you had to go. Thanks for hanging out. We'll see you. We'll be back Monday. I don't know with what. I keep saying that. But we'll be here. uh that was Stormy. I think she was going to try to find out more information on that one. Yeah, she had to leave. So the problem is you like scroll through the news and be like, oh yeah, and then you realize it's going to be probably 2 years before it ever goes to trial. I can show you. It's very, very quick, and if you blink, you'll miss it. The worst opening statement I have ever seen so far in my journey. It was also the worst defense, one of the worst defenses I've ever seen. I think the guy was sleeping. I think his defense attorney was sleeping. Oh, I know what we can watch. I'll show you this, and then uh, we can watch the sentencing from the Ohio, the vacay mom. All right, where did I put that? I had it yesterday. Here it is. So this guy was, oh, I even have it I even have it still there. Give me a second to make sure that what are you double dog daring me to? Lost my stuff from yesterday.
Good morning, ladies and gentlemen.
Not her. Even though you guys couldn't hear it. Her opening was about, I don't know, 13 minutes or so, 14 minutes. Didn't need to be long. Oh, I'm going to show you. Don't you worry. So, this guy, I know this will shock you when I tell you that it took place in Wisconsin. So, the guy in the white shirt, he is accused of, I think I think he was accused of robbing some people in Chicago, taking their car, robbing and I think unaliving them, taking their vehicle, and then driving to Wisconsin where he was spotted. And then that's the defense attorney. He would have been better as a caveman. So he was spotted in like a parking lot of a convenience store. And so the officer that spots him, he waits for other officers to show up. They do. They try to get him out of the vehicle, and that did not go well. He ends up getting out of the vehicle, I think trying to run. I mean, there is a highway, like there's a busy road next to this place. And he takes off. He turns and fires at the officers. They have, in turn, they have released the dog to get him. But they start firing back. So he's in trouble for that. They're saying that he pew-pewed the dog. The dog is alive. So they're saying all that. And he would have had to also go back to Chicago for his charges there as well. It was a very short trial. The judge in this tried something else that I've seen. I don't remember the other trial that he did. Maybe the Jensen trial, the antifreeze guy. The dog does not bite the wiener. No. but he should have. No, sorry, the dog was injured. He wasn't doing anything except being injured. And they were trying to get him because now he's injured and he's running. And I believe he started kind of running into traffic. It was bad. So, anyway, this is the opening statement that I assume a public defender gave for him. And nothing against public defenders. There's some good ones out there.
Testimony, ladies and gentlemen, I will ask that you find the defendant guilty of all 9 counts. Thank you.
Thank you. Who's doing the defense's opening? Go ahead.
Thank you.
Ladies and gentlemen of the jury, as the state mentioned, you're going to hear a lot of evidence and you're going to see a lot of video footage during the course of this trial. All I ask is that you keep an open mind, use your own eyes and ears to determine what happened in this case. And most importantly, I ask that you hold the state to their burden of proof to prove each element of each charge against Mr. Brown beyond a reasonable doubt. I'll be back after all the evidence has been presented, and I will ask that you return a verdict of not guilty. Thank you.
That's it.
Thank you.
Not, this is why he didn't do it. Not, couldn't have been him. Oh, and he looked to be sleeping during most of the trial. He didn't ask questions to the majority, if not maybe one witness he asked a question to, but he did not ask questions he did not cross-examine anybody. I don't believe they called any witnesses because, yeah, Cousin Vinny did better, even with his shorter opening. But yeah, I mean, that's it. Yep. He could have asked, they could have prove, because in the end, when all the projectiles are flying and the dog gets hit, how do you know whose projectile hit the dog? Didn't ask. Didn't ask at all. Because I could have taken a charge off of him because he did get charged with that. Now, the guy, he has some issues. I'm not sure what happened to him because I went to watch his sentencing and he would not come out of his cell. This guy here that I'm giving all kinds of crap to, he looked way better. The hair was clean cut. I think he was clean shaven, more awake. He had been trying to get him to come out of his cell and to come to sentencing, and he wouldn't. And then I just honestly, I never checked back after that because there's some issues going on there. I don't know if the guy shouldn't be out, probably isn't out. And then he also had charges in Illinois that he still had to contend with at some point. So, but yep. Other than my cousin Vinny's shortest opening statement I've ever seen in my life. I didn't like it. I don't like great big long ones either. I feel like there's a "that's what she said" joke in there. Hey, it's Friday. Leave me alone. But that's that. All right. So if you guys want to watch the sentencing with the vacay mom, we can. I said that was in there. Oh. All right, so let me go get this. I have it all ready. And I don't know if you guys want to do it or not. Actually, at some point in time, I don't have any idea when I did it, but I did save the Zachariah Anderson trial. I have all of it from Law and Crime. I saved it. So if we ever want to go watch that and you can see your favorite Michael Gravely again and all his glory and wonder, and why so many people are not convinced of this guy's guilt, we can do that at some point. But there's also, I can tell you, I can give you places to go look and watch it as well, watch shorter versions of it. That's also in Wisconsin, in Kenosha, of the guy that was, they called it the obsessive ex-boyfriend stalker trial. He was not a stalker. I don't believe he even had anything to do with it. I think the people that pointed the police in his direction probably should have been looked at a lot harder than they were, because I don't think they were looked at all. So he's accused of unaliving his ex-girlfriend's new boyfriend and getting rid of him. No body. Yeah, Wish Martin. Yep. And yep. So he's accused of doing that. The evidence as we were watching this, one, he wasn't obsessed and he wasn't a stalker. And we kind of went over this in the Martise Fuller trial, that he was stalking that girl. And so him and Zachariah and his ex-girlfriend were getting ready to go into a big custody dispute. And I think, allegedly, my opinion, have no proof one way or the other. I just think she set him up. So a lot of other people haven't, I don't know if they have came right out and said that they think that, but Zach's brother and sister ended up, they were in Law and, like, I think watching on Law and Crime, and then exited that pretty quick because the comments were so awful. And they actually ended up in Legal Vice's chat, and he vetted them to make sure, especially his sister, because she was in there the most, to make sure that it was her. And it was, and so she would be in the chat watching, and we watched every day, and we were just, all of us were just like, there is no evidence here. There's nothing. The DNA experts were arguing with, was that blood? Was it not? It was just a red substance. There was just a lot. And good, I'm glad I'm not the only one. And the jury, they deliberated more than a day. Uh, and then when they came, and which I thought was good, when they came back and the first verdict was read and it was guilty of the charge of stalking, I thought, okay, good. That they're just going to do that. He'll be time served, fine, be out the door. They gave him something. But then nope. And they went on to read the rest. And it just shook me. Honestly, I could not watch trials for a while after that. I didn't want to watch any trials after that. I was so just, after I watched everything that happened in that courtroom, and then you watch, so like Court TV has taken it all down. Law and Crime has taken it all down. Court TV cut it into snippets. So you can only see what makes him look bad. They don't take anything that makes Gravely look bad or makes the girlfriend look bad or shady. They don't take any of that. And none of that evidence was allowed in for there's something called a Denny motion there. And basically, the defense was not allowed to point the finger at somebody else to say, did you investigate these people? Did you investigate this? And they weren't allowed to do that. So it was so messed up, Gabby. It was so messed up. It's a long trial, though. I think it's a couple of weeks, and that's going every day because Judge Schrader in there is not the same Judge Schrader that was there at Rittenhouse. He's fallen by this time. He's walking with a cane. He's had a head injury. He's not the same guy. And he tells a lot. He trails off a lot, tells a lot of stories that don't really have anything to do with anything. His family was asked to write letters for his sentencing, and they were asked very specifically to what to include in those letters, and they did. And when the defense asked why they didn't, why aren't you reading letters? The judge made fun of them, and it's like, well, one says like, I was talking about my dog, and I was doing that. I'm like that. And then his brother came on and was talking about, that's what he wanted. That's what the judge said they had to tell about themselves. They had to tell about their families. And then he came on and just made fun of them. Oh, Gabby, that's not nice. It's Rittenhouse without the W. That poor kid. He had a breakdown. He's one of the reasons why I don't watch certain channels anymore, because I know the evidence that needed to be shown that was going to prove his guilt or innocence, and they weren't showing it. So I just quit watching them. So people can agree, disagree, whatever. At the end of the day, that kid's life is ruined no matter what because it's ruined. It's over. He may not be in prison, but he's in prison. Because it broke. They're broke. They didn't have anything to begin with. And then now imagine trying to go, would you want to go eat in a restaurant if somebody knew you were him? Like, oh, here, the cook made this especially for you. No thanks. No thanks. But it's why I just don't talk about it, because it's just, it's either just, it's divisive. Yeah. Oh, my husband and I, like, it was crazy. Yep, one bad decision, and because my husband and I were, like, arguing about it, and he's like, "He should have never been there," and I said, "You're right, nobody should have been there. Nobody should have been there." And if he was gonna be there, he had just as much right to be there as other people, but, ugh, it's whatever. I said I wasn't gonna talk about it, and then I talked about it. Alright, let's see this. No, quit apologizing. That's my job. I apologize. I just have this saved. Don't have any timestamps on any of it, so but I don't think it's long before the judge comes in. So I think Felicia said she took a plea deal on that.
Court please now open pursuant to adjournment. The Honorable Judge Brendan J. Sheehan.
Thank you. You may be seated. Okay, good morning. We're here today on the state of Ohio versus Crystal Candelario. That's you, Ms. Candelario. This is case number 23-682-241. Representing you, Ms. Candelaria, is Mr. Derek Smith and Mr. PJ Mulligan. Representing the state of Ohio is Ms. Anna Ferelia and Ms. Jordan Mason. Before we start, we've had numerous pre-trials on this matter, and we have an interpreter here that's been involved in all the proceedings. And Robert is here. Robert, do you want to stand up? Robert, you've been involved with the court. Your training and credentials as an interpreter has been reviewed by this court. And you are familiar with the National Association for Judiciary Interpreters and Translators, the Code of Ethics and Professional Responsibility, and you've interpreted here many times in this court. Robert, I want you understand that you are to be a neutral party who is here to facilitate communication, and that you should not offer advice
An hour and a
or
half.
project your opinion into these proceedings. You understand?
And I will have to go.
Yes, Your Honor. All right. So with that, is there any objection to Robert being the interpreter?
Not on behalf of the state, Your Honor.
No, Your Honor.
All right. So Robert, you want to raise your right hand? You do solemnly swear that you will interpret accurately, completely, and impartially, using the best skill and judgment in accordance with the standards prescribed by law, and follow the official guidelines established by this court for legal interpreting or translating, and discharge all of the solemn duties and obligations of legal interpretation and translations as you shall answer unto God. Please say I do.
I do.
Thank you, Robert. All right. Okay. All right. So We're here today for a sentencing hearing. Ms. Candelaria, on February the 22nd, you pled guilty to count 1, which is titled aggravated murder, an unclassified felony, which is potential sentence of life with parole eligibility after 20 years, life with parole eligibility after 25 years, life with parole eligibility after 30 years, or life without parole. You also
Wait, are you guys telling me she knows English? She speaks English? We don't need an interpreter? He's interpreting to her, Gabby. That's why he stood up. But he's just doing it so the sound will go to her, not just out to the microphones. I promise you he's not sucking on the book. Yes, he's not sucking or sniffing the book.
also pled guilty to count 5, endangering children, which is a felony of the 2nd degree, which is punishable by 2 to 8 years and or a $15,000 fine. And there's also the Reagan Tokes advisements I advised you of, which is whatever sentence this court imposes on count 5 must be served 50% of that number. So we went through that at the plea, so you understand.
Does she not need one?
At that time of the plea, we requested a pre-sentence investigation report. We received a report from Michael Rahm, R-A-H-M, on February the 28th. I shared it with both the state and the defense. Ms. Fralia, Mr. Smith, have you had a chance to review this report?
I have, Your Honor.
Yes, we have.
Any additions or corrections to this report?
No, Your Honor.
No, Your Honor.
I also have received sentencing memorandums and mitigation reports from the defense by Mr. Smith and Mr. Milligan. And I also received a state sentencing memorandum by Ms. Ferreira. With that being said, is there any additions or corrections that this court needs to review?
With regards to the briefs, no, Your Honor.
Briefs, yes.
No, Your Honor.
Ms. Candelaria, are you ready to proceed to sentencing?
Yes, Your Honor.
That being said, this is the procedure we're going to follow. I'm going to turn to the state first. Ms. Ferreira, you'll put on your sentencing hearing and allow you to present evidence and victim impact statements. And then when I hear from the state and all the state's representatives, I'll turn to the defense. I'll hear from you, Mr. Smith, and anyone who wishes to speak on behalf of Ms. Candelaria. And then I'll hear from you, Ms. Candelaria, and then I'll impose my sentence. Okay? That's how we're going to operate. So with that being said, Ms. Ferreira, are you ready to proceed?
I am, Your Honor. Thank you. Good morning, Your Honor. We're here on a very tragic case. The state of Ohio has prepared a PowerPoint presentation.
Yay.
Because the state wants you, when you impose your sentence, that you look at Crystal Candelaria's actions. And anybody that knows me or has been in this courthouse would know that I talk about actions in all my cases, because as adults, we are responsible for our actions and there are consequences to our actions. So let us begin on this fateful day that Jaylene Candelaria lost her life. If in fact we would have gone to trial, the evidence was going to show that Crystal Candelaria left the state of Ohio on 6/4/2023. She leaves because there is a receipt that's found in her car that she is in Taylor, Michigan. Unbeknownst to Ms. Candelario, her neighbors had Ring doorbell, and the Cleveland Police Department Homicide Unit has gone through 648 hours and videos of the Ring doorbell, which you're going to see in this presentation. With regards to Ms. Candelaria, she returns to Cuyahoga County on 6/6 at 7:41 a.m. So at this particular point, we have reason to believe that this child was left alone for 2 days now, and she returns on 6/6/2023. Additional cameras show her again at 11:51 on 6/6 and on 5/24 of 6/6. She is taking a suitcase and now leaving Cuyahoga County. We have a map and a flock camera which shows her on, I believe it's Lafayette and Charter northbound at 6/6 at 20:05, which is 8:05 p.m. And that's a flock camera. Through the search warrants, we were able to retrieve her Spirit airline tickets that showed her departure and her return from Puerto Rico. She was gone from 6/8 to 6/11. And it's interesting, Your Honor, because in the defense memorandum, it says that her abrupt stopping of medications played a significant role in her ability to function as a parent and make sound decisions. So when we look at, these are items from her phone, her actions indicate to us that she is in Puerto Rico having a good time with friends, and that there is not a care in the world about the 16-month-old that was left alone in the pack and play. These pictures show somebody who is showing some discretion and judgment because she's having a good time. Meanwhile, this child is in a pack and play. She returns to Detroit, and while she is in Puerto Rico, the detectives were able to locate on the Ring doorbell that on 6/9/2023 at around 1:04 a.m. in the morning that you hear this child crying.
You guys hear that? It's giving me chills.
So now we have Miss Candelaria's car. She's returned from Michigan, from Puerto Rico back to Michigan, where she was with one fellow and then traveled to go see another fellow traveled to Imlay, Michigan to be with another fellow. So that's from 6:12 to 6:15. Her car is found on all these flock cameras. Not once is she returning to Cuyahoga County. Now we turn our attention to June 16th at 7:36 a.m. She is back in Cuyahoga County. Her car reappears in front of her house. She goes in and she finds her daughter dead. She takes the time to redress her, and then she calls 911.
Friday, June 16, 2023, 07:47 and 26 seconds. We were released at Petrico, someone in your police, fire, EMS. We were released in police, fire, EMS. What's that? Tell me the address so we can help you. Okay, is there a single subword apartment? What's your name? Crystal. What's your last name, Crystal? Crystal Candelaria, please help me. And what's your number in case you get what's your last disconnected? 217-882. Tell me what's going on. What's going on? I need you to tell me what happened. Okay, I'm gonna give you a few moments to calm down. Crystal. Please listen to me so I can help you. She don't respond. She's white. Who's white? I understand you. Tell me who's white. Who's white? Your mom? Is it your mom? I have mom, yes. Do you live here? Oh, your mother's dying? She's dying. I'm going to do this for profit. Please, I need help. How old is she? I'm gonna get you over to my
And then she's so overwrought with emotion on June 17th that she picks up and goes back to Michigan to meet up, not with the guy that she had gone to Puerto Rico with, but the other guy that she was seeing. And in her house during a search warrant, there was found this notebook that had written harm from neglect. This is the location where Jaylene was housed for 10 days without anybody being present, any adult, in a 3x2 pack and play with maybe a bottle or two of milk and maybe some crackers. And the mattress that was found was urine laden and feces strewn throughout the pack and play. Now, this is where it begins, Your Honor. I come from an Italian Catholic family, and both my parents were immigrants and they spoke broken English. And we have this good interpreter that has been with us during this whole case. This is the very first interview, the crying of the 911, and this is the first interview that she has with a detective from homicide. Again, pay attention to her actions and how she speaks to this detective.
But in the last week, she get a vomiting too. Remember right now when you mentioned the vomiting. She get a vomiting the last week, Monday and Tuesday, two times. But I was trying controlling because I know I give to her Tylenol or something, for controlling the vomiting.
Okay. Come on, sir. This is my supervisor, Sergeant Gomez.
I'm telling I give to her when she get a valley or vomit. Hola, ¿qué tal?
Yo soy la secretaria de
Just to take note, Your Honor.
So yeah, that's the situation, and after that, she was refusing to the food, and she was with no appetite. I say, oh my God.
This is after last Monday and Tuesday when she was throwing up?
Yeah.
Okay.
Yes.
Are you talking about Monday and Tuesday, like 4 days ago?
Yeah,
Okay.
last week, yes.
Okay.
Yes, because we almost done this week, so I talk about,
Because what, this week?
This week, I talk about because we almost done,
Oh, we're almost done with this?
Yeah.
Okay. All right, so that was just Monday and Tuesday of this week, she was throwing up.
Yes.
And then how was she Wednesday and Thursday?
She was with no food, just with a meal because she was refusing. Maybe it's because she get a vomiting 2 days, before.
Yeah.
So that's why I was scary because I say, oh my God, I need to go to the hospital because she doesn't eat anything, and she was lose tiny, her weight. I lose, her weight. But right now, in this morning when I wake up, she was asleep. She sleep every day 12 hours.
Okay.
She sleep like at 9 p.m. through 9 or 10 a.m.
Okay.
12 hours. So in this morning I was sleeping too. I never wake up. She was.
What happened? What was going on last night?
Last night she was crying a lot, and I see one moment when I was take a shower, and she was screaming like I don't know, probably she get a pain.
Okay.
Maybe.
About what time was that last night?
Maybe at 7 or 8 p.m.
Okay.
So she was screaming like probably for pain or something like that. In this morning when I wake up, I took her in the morning for JD, wake up, and she wake up, and when I see her, I see she looks like a really, really dry, like ¿cómo se dice cuando una persona se chupa, o sea, se kind of like,
Oh, like her face was sunken in?
So,
Okay.
me asusté y dije,
And then she is then brought into homicide. She's arrested and brought into homicide and has another conversation with Sergeant Gomez and Detective Powell. And she continues now to perpetuate her lies.
What time did you go to Detroit, Michigan on Monday? Monday morning? Okay. On Monday morning, what condition was Jamie in? She was okay. Was she awake, asleep?
No, she wasn't sleeping.
She was sleeping when you left? Sorry. You went there on Monday at what time?
Maybe 7 a.m.
In the morning?
Yeah.
Okay.
Every evening, I don't remember something.
Early in the morning? But when you left out, you said you were sleeping in her playpen? Okay. So you go to Michigan. What time did you arrive in Michigan?
You say through here. Espera, espera, espera. Ahora con 30 minutos, 2 hours and 30 minutes.
2 hours, 30 minutes? Okay. So you get there, and when you arrive there, who you meet up with?
Yo llegué a un hotel, pero yo trabajaba de Uber, así que yo me puse a trabajar directamente en Uber.
She stayed at a hotel and she regularly started working at Uber.
Pero ya después fui a visitar a otras amistades alrededor.
She went to visit some friends.
Y
Who did you go visit?
amistades.
Give me a name.
Oh, David, that's the name.
David?
Yeah.
Later. So you arrive in 2 hours later, you get a hotel. Where did you stay?
No me recuerdo bien en la ciudad que estaba ni el hotel.
Okay, come on. David went to Detroit, Michigan. You don't know what city, you don't know what hotel, you gotta come out with something better than that.
No,
Okay.
pero el hotel de donde él se estaba hospedando,
No.
Super Eight.
Where you were staying, not David, where you were staying. We're not talking about David.
Super Eight, that's it.
Super 8? Yeah. All right, so you arrived in 2 hours later, you said it's Super 8, you mentioned something about Uber.
Yo estaba trabajando en Uber, sí.
She was working. Why would you go, hold on. Why would you go work Uber in Detroit, Michigan?
Porque yo
Instead of doing it here in Cleveland,
Sí, porque
where your daughter is?
yo también trabajaba aquí en Uber, aquí en Cleveland.
Okay, but why go over there, not do it here? Why not do it here? Your daughter's here.
Porque me iba a ver amistades también en Michigan, entonces aproveché.
Friends over there in Michigan, so she took advantage of the fact that she was over there to visit people while she worked over there.
Pero no era siempre que lo hacía.
But not always. That's not, she didn't do that always.
And I'll say this the wrong way. At what point did you think that it would make sense to leave her here while you was in Detroit?
Dice que no trato de la manera mal, pero ¿en qué momento tú pensaste que está bien
Por pasear, por
to travel,
por pasear,
Why not travel with you?
¿Por qué no llegaste a ir contigo?
porque yo pensaba regresar el viernes y ya quedarme con ella, o sea, era algo rápido, eventual, que no.
She said that because she had planned on returning on Friday and spending time with them, so
Porque no me iba a quedar en la casa de nadie,
she wasn't gonna stay at anybody's house.
But why not bring her with you if you already knew that she had a condition going on at the time?
Si tú sabías que ella tenía una condición, estaba enfermita,
She needed
¿por qué no llevarla contigo?
porque por eso mismo, por yo pasear, por
Because she wanted to have a good time and travel.
And this is the second interview that she had.
Cash in your wallet to purchase the second, but you took out money for the ATM machine, that's what you used.
siempre la uso para
Alright, so let's just start, we're gonna wrap up some stuff here. Okay, so you were at your house in June 16th, okay, the day we were there. You woke up at 7:20 in the morning, right?
Él me estaba diciendo acerca de que tiene todo mi seguimiento.
Okay.
Él me dijo hace un momento en inglés
¿Qué tiene que?
que tenía mi seguimiento de donde yo me movilicé y todo eso.
Yeah, we have you on video, your car coming home at 7:36 in the morning. What time are we gonna see you leaving your house and when? What's the video gonna show us? When we look at this video some more,
Okay,
okay? Cuando nosotros empezamos a ver el video, okay? ¿Qué este video nos va a enseñar a nosotros?
¿A qué hora tú saliste de tu casa y cuándo? Nos está enseñando tú regresando a las 7:36 de la mañana. Pero a la hora ¿y qué día? Piénsalo bien, porque el video, el video no miente. Okay? I'm telling you, think about it really good because the video does not lie. What is the video going to show us? Is the video going to show us that you left your house on Friday? Because it's showing you coming back, but when is it showing you leaving? Because we're gonna look at the video and it's gonna show us and it's not gonna lie. Think about your answer. Think about your answer. This is la oportunidad tuya para decirnos la verdad, porque nosotros vamos a ver el video. Sí, y si no nos está diciendo la verdad, lo vamos a ver. Y vamos a ver que tú no estás mintiendo. Sí, y él me está diciendo que va a haber más problemas al respecto. Va a empezar los problemas.
So, Your Honor, with regards to Jaylene Candelario, she died a very awful death for being 16 months old. Dr. Elizabeth Mooney from the medical examiner's office is here and would like to make a statement. She was the medical examiner that did the autopsy, and the state of Ohio is going to provide you the autopsy and autopsy photographs to make this part of the sentencing record. Dr. Mooney?
For the record, we'll call this Stacy Exhibit 1.
Well, this is going to be awful.
Good morning.
Doctor, for the record, can you say your name and spell it for the court reporter?
Yes, my name is Dr. Elizabeth Mooney, and it's spelled Mooney. I am currently employed by Cuyahoga County Medical Examiner's Office as a forensic pathologist and deputy medical examiner. In this capacity, I was assigned the task of performing an autopsy on little girl Jaylene Candelario in order to determine her cause and manner of death. Unfortunately, this is one of the most tragic and unfortunate cases I've had in my career thus far. So today I speak on behalf of her and her findings with the course of my examination. We received Jaylene at the medical examiner's office from the scene of her residence, at which time she was clothed in non-soiled clothing, indicating her body had likely been dressed prior to first responders' arrival, as they had mentioned before. So at autopsy, I examined the body of a very emaciated female toddler. At this point, she weighed 13 pounds. Upon review of medical records, this indicated approximately a 7-pound weight loss since her previous doctor's visit less than 2 months prior to that. The eyes were sunken and she had temporal wasting in her face. In addition to that, the skin showed markedly decreased turgor, meaning when I pinch the skin, it remains in that tented position, indicating severe dehydration. In addition, there was abundant fecal material present caked on the fingers, the fingernails, the hands, the feet, as well as the soles of the feet. The same material was found on her lips, which were very dry and flaking, as well as in her oral cavity caked to her teeth. She did have some diaper rash appearance, as well as fecal material adherent to those areas. Of note, the body was essentially free of significant injury, with the exception of dried excoriations or scratches to the face region predominantly, and whether or not these were inflicted to herself in a conscious or semi-conscious state while she was dying, I'm unable to determine that. Very early decompositional changes were present. This included faint discoloration or green discoloration of the abdomen. These are typically changes that we see within 2 to 3 days following death. No additional changes to suggest that she passed away prior to this were found externally or internally. Upon internal examination, I continued to find evidence consistent with starvation and dehydration. These included pale discoloration of the musculature, which was minimal. There was a decrease in intra-abdominal fat to the point of transparency as her body tried to feed upon itself for nutrients. Her stomach contents consisted of less than 2 milliliters of brown mucoid material. This is about equivalent to the distal part of my thumb, a very small amount. The rest of her bowel just contained patchy fecal material, but very minimal throughout. Her organs, including her liver, kidneys, and thymic gland, showed evidence of stress, specifically microscopically on exam. I found no additional evidence of significant natural disease going on or congenital abnormalities. Following my exam, I submitted body fluids for additional toxicology and chemistry testing, which further confirmed my gross findings that she had passed in a state of severe dehydration. Her kidneys had failed, and she was in a state of ketoacidosis, which leads to coma and eventually death. As such, I determined the cause of death to be just that, starvation and severe dehydration due to pediatric neglect. To come to the exact wording of the cause of death was based on my findings, but also the medical definitions, which I'd like to reiterate here. Dehydration, and specifically starvation, is a lengthy and continuous deprivation of food as to cause suffering or death. Pediatric neglect is the failure of a caregiver to meet adequately a child's basic needs, including physical safety, protection, food, clothing, shelter, education, medical or dental care, and supervision. In other words, neglect for Jalen's basic needs from a caregiver resulted in her death. As such, I ruled this manner to be homicide. Most homicide deaths involve acts of violence inflicted from one person onto another, but this case involves a failure to act appropriately to support another who is dependent on them, falling into a homicidal manner. In the absence of more advanced decompositional changes, I believe that the pain and suffering she endured lasted not only hours, not days, but possibly even a week. This is a pain that comes from an extreme thirst and hunger. It also stems from an inherent terror of isolation or the lack of someone present to provide that. My knowledge on the depth of this suffering may not be as extensive as a medical or a mental health professional, but as a physician with psychiatric and pediatric training, I feel comfortable stating that the deprivation of food coupled with physical isolation and caregiver abandonment would be terrifying. We know that babies and children cry when they're hungry because it's unsettling and it's uncomfortable. That's almost immediately after birth. We also know that children as early as age 4 to 5 months experience separation anxiety, with the most extreme anxiety around 9 to 18 months. Jalen was 16 months old. This feeling of abandonment for days on end, coupled with the pain of starvation and extreme thirst, is a type of suffering I don't think any of us could ever fully fathom. So as a forensic pathologist, it is said that we are the voice of the dead and given the responsibility to speak for those who can't. So this morning, I'm honored to maintain that mission. Thank you.
In addition, Your Honor, just so the record is very clear, the state of Ohio has tried repeatedly to contact Jalen's extended family, and absolutely no one has called the prosecutor's office, has returned a call from the prosecutor's office, has done nothing to acknowledge that Jalen was even part of their family. So if people come in this morning, it's going to be on the side of Crystal Candelaria, because on the part of Jalen, in addition to Dr. Mooney, who speaks for the dead through autopsy findings, Sergeant Teresa Gomez and Detective TJ Powell are going to speak to you. As you also look behind me, it is law enforcement, whether it be from Cleveland Homicide, from the FBI, from the district, from EMS. These are all the people that participated in this case, and that they are here to be the family for Jalen Candelario, because her own family did not have the courage to call the prosecutor's office and ask what was going on with their case. They were more concerned with their own daughter. TJ is going to, Sergeant is going to speak first. Do you want her to come to the podium?
Absolutely. Same thing, Sergeant, just say your name and spell it for our court reporter so she can have an accurate spelling.
Teresa Gomez, Teresa. Gomez. Morning, Your Honor. Your Honor, thank you for allowing me to be the voice for Jaylene Candelario, a beautiful angel whose life was cut short for no good reason. This tragedy should have never happened. I am Sergeant Gomez from the Homicide Unit. The entire Homicide Unit, Cleveland Homicide Initiative, and our partners from the FBI are here today in honor of baby Jaylene Candelario. When we were first notified of this horrific case, we were all heartbroken. But when we started digging deeper into the investigation, it was beyond horrific. It was revealed that the defendant, Crystal Candelario, left her own child alone for hours, which led to days, which led to weeks. This 16-month-old baby was left alone in a pack and play to fend for herself for 11 days with no food, maybe milk, the clothing she had on, and the diaper she was wearing. This baby loved her mother, she needed her mother, and her mother betrayed her. Mothers usually want their children to have a long, happy life, but Candelario placed more importance on a vacation in Puerto Rico with her boyfriend than the health, safety, and well-being of her own daughter. She chose to satisfy her own needs and desires over that of her own child. Jaylene's life ended because of her selfishness and disregard for Jaylene's precious life. Candelario violated Jaylene yet again when she placed her little body in a clean outfit in order to orchestrate this facade that she was trying to portray for the investigators, either before or after she called 911. But Jaylene told us something different when we saw her eyes sunken and wide open. We later learned that sunken eyes is a result of severe dehydration. To the naked eye, it appeared she had dirt in her mouth and fingernails. It wasn't until the next day that detectives learned that the dirt, in fact, was feces. Detectives also began to gain clarity as to what really happened to Jaylene. Candelario's fabricated story, which she initially told detectives, began to unravel. There's no way things could have happened the way the defendant said they did, which left us with many unanswered questions. Detectives gained knowledge of the fact that Candelario left Jaylene by herself for more than 10 days. Many hours of video surveillance revealed all of the comings and goings of Candelario from June 5th through June 16th of 2023, when she discovered her daughter deceased. Investigators watched a total of 628 surveillance videos, which also included audio. On June 9th, audio surveillance captured the final time Jaylene is ever heard crying. Myself and the people sitting behind me, many who are mothers and fathers, are tormented by the thought of what Jaylene endured and what her last hours on earth were like. Any of us and thousands of others would have jumped at the opportunity to take care of this beautiful little girl. Jaylene died a long and agonizing death, afraid and alone, while her mother enjoyed the beach and sunshine. This is a case that myself, all the people behind me, and everyone around the world will have branded in our minds and in our hearts forever. Jaylene took her last breath, and our only hope is that Jaylene found herself in the arms of Jesus, feeling his warm embrace and love, something she did not receive from her mother. Jaylene, you will never be forgotten. Thank you, Your Honor.
And Detective Powell.
Same thing, detective, if you don't mind, just please say and spell your first and last name.
Yes, Detective TJ Powell,
Thinking that.
POWELL, assigned to the Cleveland Police Homicide Unit. I was the lead detective investigator on this case, and I can honestly say, Your Honor, in my 17-year career as a Cleveland police officer, this by far is the most horrific case I've ever had to investigate. Now, I've been a detective for 10 years. First and foremost, I want to thank the entire homicide unit, the entire Cleveland Police Department, prosecutor's office. As you see, we're here, we're Jaylene's voice. Fortunately, there's no family on our side, but we're her family. I wrote a short poem, just something in commemoration of Jaylene's life. J is for the justice that'll be received today. A is for the angel wings she earned on that joyful day. I is for the incremental repetition build up of suspense for an innocent bystander's death that clearly makes no sense. L is for the lack of love while alone for 11 days. Y is for a young life that was taken away. N is for new eternal life Jaylene gained on that day. No child should ever have to die this way. Jaylene's life truly mattered. Unfortunately, she died trying to survive off of her own urine and fecal matter.
Lastly, Your Honor, you're going to hear that Ms. Candelaria was depressed. And no one more than I appreciate mental health and mental health issues and the programs that this court and my office have tried to implement to help folks with mental health. This is not the case here. This is not the case at all. Her actions speak louder than words. She had the wherewithal to leave Cuyahoga County and drive to Detroit, to be not with one man, but with two, let alone leaving a child, her own flesh and blood, in a pack and play. And during the time that she has been locked up, she has been making plans for the future, talking to other folks at other jails, other prisons. She had a conversation, which I find more disturbing than not, but on November 26, 2023, instead of wrought with emotion, wrought with guilt, crying about the death of her child, she's talking with a friend about her trip to Puerto Rico and what a blast it was and how much the car cost. And they got a truck versus a car, even though it was more expensive. And they were concerned about the other woman that was on the trip because she liked to spend money. And they spent money on food. There was never mention about her daughter in her phone calls. And in fact, on January 6th of 2024, she's talking to her mother, who she repeatedly talks to. And they talked about God is forgiving, God is this. You also have to take responsibility for your actions. And God isn't in the courtroom. That's why we have judges, and that's why we have the law, because we have to follow the law. But this is what she says, because she wants to make us believe that she doesn't understand the English language. She goes on to say, there are people who have gone free here, killing people. I mean, imagine, intentionally, and mine was practically an accident. Because it was not like I did it intentionally. It's not like I picked up a gun or a bat or the girl bled or something like that. That's it. It was practically the same thing that happened to me a few days prior. I had the same thing happen to me days prior. And I mean that day. that it happened. That same situation happened. Were you starved when you were in Puerto Rico, Miss Candelaria? Did you not have a glass of water to drink when your mouth was parched? It is really pretty pathetic, Your Honor. Because, you know, we always stand before you and say that the purposes and principles of sentencing are to punish the offender and to protect the public. And, you know, in the sentencing memorandum, the defense says, well, she's not going to do it again. Well, no, she's not going to do it again because she's going to prison. But it's the fact that she did it in the beginning that sticks with us. You don't do that. She was a mother. She got a title that means something in this world. Animals take care of their infants better. The thought of this child dying every day while she's having fun, humanity can't stomach that. And those are the actions that need to be punished. She abandoned her daughter and left her for dead. So yeah, she didn't see blood. She didn't see the aftermath of a baseball bat. But what she did see were her eyes open, looking at her saying, why did you do this to me? Thank you, Your Honor.
Thank you, Ms. Furley. Okay, we're going to turn now to the defense. Mr. Smith.
Thank you, Your Honor. May it please the court, everything that I'm about to get into here today, and my client agrees with me, is no justification for her actions. And what the prosecution said, actions matter, and these actions are narcissistic, selfish, abhorrent, absolutely worst parenting imaginable. She pled to aggravated murder. She pled to child endangering. So everything we're about to tell you is mitigation. Just to kind of give you an understanding of who this person is. So she came over from Ecuador 2016 with her grandmother. She was here for a few years. Her parents came over and they lived together. She had her first daughter, Amaya, while she was married. She subsequently got divorced, was a single mom raising Amaya. Met the father of Jaylene in Ecuador. They had a relationship that unfortunately turned violent. While she was pregnant with Jaylene, he became physical with her. She came back to Cleveland, never to see him again, gave birth to Jaylene. He was never involved in Jaylene's life. She had two daughters on me with the help of her parents. She was struggling emotionally, physically, trying to work, support these children. Fast forward to 2023, it's just overwhelming. She even tried to harm herself, took 20 Motrin, ended up in Metro. In early February of 23, after spending just a few days in her room alone, her mother went to check on her, asked her what was going on. Her whole side of her body was numb. Didn't know what was going on. They took her to Hillcrest Hospital. She was admitted there, and they were doing some evaluations for her migraine. She was complaining about headaches and weakness, facial drooping, thought it was possible stroke. They put her on IV Depakote, which is a anti-seizure, also used to treat manic disorder. And at the end of the day, after evaluations, she was clean, nothing wrong with the brain. They gave her oral Depakote and Effexor, two antidepressants, and sent her home. She was not very clear on what those were, but she was taking them supposedly as directed. And then she returned to Hillcrest Hospital again in March. And there was a note from the doctor saying that she should have had plenty of Effexor, but she's saying that she's she's out and she needs more, and she's coming back with the same problems. So they had her evaluated again, and they were saying that her anxiety and her stress was the trigger for these physical manifestations, what was happening to her, for the loss of sensation inside of her body, the numbness. And they prescribed her more Depakote, more Effexor, and also Atarax to help her sleep, because she wasn't sleeping. And this is in March of 2023. And, take the medications as prescribed. And then medications ran out. She wasn't feeling any better. They weren't working. She stopped. Not supposed to do that with these drugs, Your Honor. These are very serious mental health drugs. And you need to be tapered off of these medications, or there could be some side effects. Not only the side effects, but the actual underlying conditions that she may have had or been suffering from are also going unmedicated at this time. And then we get into her trip. And to be honest, I'm not going through that again. That's the worst thing I've ever heard. And I commend the prosecution and detectives for their work. It was unimaginable, terrible, and I feel for all you guys having to deal with that too, and her family as well. It's when the prosecution showed pictures of her on her trip. Pictures can be deceiving. Personally, for having myself suffer from depression and anxiety, you can't tell what a person's going through from a picture, what they're dealing with on the inside. And I'm thankful for the support that I had from my family, my friends, my doctors. She didn't have any of that. She was hiding it from herself, from her parents. Nobody knew what she was suffering from. Her doctors even thought it was migraines and possible strokes. And to be honest with you, when I first met her, Your Honor, after this happened in June, I met a person that was devoid of emotion. Just after hearing what had happened on the news, and then I get the call, she wants to meet with me, and I go talk to her. It was not what I expected. She had no emotion. She couldn't explain anything. I had no idea what I was talking to. But I'll tell you right now, this is not the same person. This person now is compliant on her medications. She's been taking them through the prison throughout the whole time that she's been in here. Again, there's no justification for her actions when she was out there, what she was doing. She could have called somebody, she could have done this, yes, but when you're in that state, when you're off medication, mismanaging your thoughts, you're not thinking clearly, her body she had to get out, and she was having fun. If she was okay, in her mind, Jaylene was okay. Of course that's not the case, but I will point to when she did finally get home, and we heard that 911 call, she didn't want this to happen. You could hear that. Help me. My daughter's not. Yes, because what your children, and you took responsibility for that. But that call, that one tiny breach from whatever was going on in her head, that reality that her daughter was dying, she was calling for help. She didn't want that. And again, Your Honor, she took responsibility. She pled aggravated murder. She pled a child endangering. Nothing's going to bring Jaylene back. She knows that. So then, after the fact, in her state, she was telling detectives whatever. She thought she had another daughter. She had a Maya she had to think about. She had her parents. And then the prosecution saying that nobody's here on behalf of Jaylene. That's wrong. Her parents are here. They love that girl. They love Jaylene. Her mother loved Jaylene. She didn't deserve what happened to her. Nobody does. But they're here to talk on behalf of Jaylene as well. They loved her. So this time around, I'd like to call her parents up to sit.
Sure. It's the same thing. Just please identify themselves and spell their first and last name. Do we need an interpreter?
Yes, sir.
Robert, are you okay?
Good morning.
I'm going to ask, do you want to go first then? Identify yourself.
Yo solo voy a hablar. Yo solo voy a hablar.
Okay, got it.
No, Luis. Yo.
Can you please say your name?
¿Puedo indicar su nombre?
Katie Torres. ¿Mi nombre?
Katie Torres.
Can you spell it for the record, Robert?
Puede letras de K con K, ¿sí? K-A-T-I-Y, ¿cierto?
K-E-T-T-Y.
K-E-T-T. T-E-T-T-Y. ¿Y Torres con S o?
Con S.
Torres, T-O-R-R-E-S.
Okay. And present with her is her husband and his name?
¿Con él es su nombre, señor?
Tu nombre. Tu nombre.
Clever Candelario. ¿Cómo? Clever Candelario. Clever Candelario.
Él no escucha bien. Él no escucha bien. Tiene un problema de audición.
This gentleman has a hearing problem.
Okay, that's fine.
Okay.
Okay, Clever con C.
Con K.
Con
K-L-E-B-R.
K-L-E-V-E-R. ¿Y el apellido?
Candelario, con C.
Candelario. Same as that.
You good? Yeah, all right, good.
Okay, bien, señor. Frase por frase.
Excelentísimos jueces de la corte.
Honorable judge of the court.
Con el corazón partido en 1000 pedazos.
With my heart ripped apart in 1,000 pieces.
Pero desde el amor y sostenida por Dios.
Speaking from love and maintained by God.
Estoy aquí para decirle al mundo
I am here to tell the world
que mi hija salió de un hogar
that my daughter came from a home
donde se creó una relación de humanismo.
Where there was relations of humanism,
valores,
values,
creencias,
beliefs,
afectos,
emotions,
calidez,
warmth,
donde lo más importante era la familia.
where the most important thing was the family.
Crystal creció y se formó
Crystal grew up and was educated
en un ambiente sano junto a sus padres.
in a healthy environment together with her parents,
Protegida y amada.
protected and loved.
Realizó sus estudios en nuestro país natal, Ecuador.
She studied and was educated in our native country of Ecuador.
Escogiendo la misma profesión de su abuelo y sus padres.
And she chose the same profession as her fathers and her grandfather,
La docencia.
teaching.
Sus años de edad adulta fueron marcados
Her years as an adult were marked by
por problemas de salud física y sentimentales.
both physical and emotional problems
Que no siempre terminaron de la mejor manera.
that didn't always end up in the best way.
Su salud emocional se vio afectada en más de una ocasión.
Her emotional health was affected on more than one occasion.
Pero entre trabajo, responsabilidades y el día a día,
But between her work, her other responsibilities, and her day-to-day life,
en un ir y venir, no logró priorizar la importancia de un tratamiento continuo.
in the middle of all that, she never ended up prioritizing or appreciating the importance of continued treatment.
Por lo que la depresión y la ansiedad y el trastorno de neurosis de conversión fueron ganando terreno en su vida.
And because of all that, her depression, anxiety, her conversion neurosis disorder, all ended up consuming her.
Razón por la que siempre sufría desmayos y pérdida del conocimiento.
And as a result of this, she suffered fainting spells and also loss of consciousness.
Con esto no quiero victimizar ni justificar a nadie.
In saying this, I don't want to victimize or justify anyone.
Solo mirar el yo interior de quien hoy está aquí sentada y siendo juzgada.
I only want to give a glimpse of the interior person, the ego of someone who is seated here and who is being judged.
Señores, las enfermedades de salud mental no se reflejan en el rostro.
Ladies and gentlemen, the sickness, a mental health illness is not reflected
Ni
in
en
someone's face,
ni en una foto.
and also not in a picture, in a photo.
Nacen y se quedan en el alma.
It arises and remains in the soul.
Solo un tratamiento a tiempo y eficaz con ayuda de terapistas y médicos ayudan a mejorarlo.
And only a timely and effective treatment by therapists and doctors can help to improve those conditions.
Mi hija no tenía calidad de vida
My daughter did not have a good quality of life
porque ella no podía pausar el trabajo.
because she couldn't stop working.
Nunca nadie imaginó que este sufrimiento terminaría en tragedia.
No one ever imagined that this suffering would culminate in a tragedy.
Y hoy aquí quiero decirle a Yailin,
And here I'm
que eres
here,
nuestro ángel, Yailin.
I want to say here before Jaylene, our angel,
Tu recuerdo vive en nosotros.
that your memory lives within us.
Siempre te amaremos.
We will always love you.
Te acuné en mis brazos.
I held you in my arms.
Tus abuelos nunca te olvidarán.
Your grandparents will never forget you.
Perdóname, bebé,
Forgive me
por vivir la oscuridad del conocimiento
for being in the dark
que me imposibilitó ver la luz y poder ayudar a
and
tu
for being
madre.
in the darkness that prevented me from seeing the light to see what was going on with your mother.
Hija querida, cuánto te amo.
My beloved daughter, I love you so much.
Lamento y me arrepiento
I lament and I am
por no
so
haber
sorry
por no haber detectado lo que estabas viviendo.
for not having detected what you were going through.
No leí tu corazón.
I could not see what was in your heart.
No me percaté del caos
I didn't notice the chaos
por el que estabas atravesando.
that you were going through.
Lamento ahora, hija de mi vida, causarte este dolor.
I lament my darling daughter that I caused you this pain.
Señores de esta sala,
Your Honor,
pido misericordia,
I ask for mercy.
clemencia y compasión
I ask for mercy, for clemency, and for compassion
para un ser humano
for a human being
que ha librado una dura batalla en su vida.
that has waged a very difficult battle in her life.
Y ruego no satanizarla,
And I beg that you not
ni señalarla.
I beg that you not demonize her and point the finger at her.
¿Quién en esta vida no ha pecado contra Dios?
Who in this life has not sinned against God?
Que levanten la mano quienes no lo han hecho.
Anyone who hasn't, let them raise their hand.
Pero como creemos en un Dios de amor y de bondad,
But since we believe in a
y de,
in a God of love and of goodness
en un Dios de perdón,
and a God of forgiveness,
Él está aquí con nosotros.
He is here with us.
Hija, te amo.
My daughter, I love
Aquí
you.
estaré siempre para ti.
We're here always for you.
Te voy a esperar toda la vida.
I'm going to wait the rest of my life for you.
Sí.
Thank you.
Un momento.
Señores excelentísimos jueces de la Corte,
Honorable judges of the court,
estoy aquí consternado por todo lo sucedido,
I am shocked by everything that happened,
dándole apoyo moral y espiritual a nuestra hija.
and I am giving moral and spiritual support
Señores
to our
jueces,
daughter Crystal.
pido compasión, comprensión, empatía, misericordia para un ser humano que ha tenido una etapa de su vida cargada de mucho estrés y preocupaciones.
Gentlemen judges,
Las enfermedades mentales
I think that's
I ask for compassion, understanding, empathy, and mercy for someone who is going through a state of stress and mental and emotional illness and worries.
or my headphones quit.
Las enfermedades mentales y emocionales no avisan.
Mental and emotional illness does not give warning.
Cada persona es un mundo.
Each person is a world unto herself.
Y el mundo interior de mi hija
And the inner world of my
se
daughter
convulsionó
was shaken
sin darnos cuenta.
without our having realized it.
La depresión, la ansiedad,
Depression,
la envolvieron hasta hacerle perder el juicio y la razón.
depression and anxiety consumed her to the point of depriving her of good judgment and reason.
Aquí está mi hija Cristel, que también tiene un motivo para seguir adelante.
Here's my daughter Crystal, who also has a motive to go forward with your help.
Con la ayuda de ustedes y esa razón,
With your help and with this motive,
se llama Amaya,
her name is Amaya.
que tiene 7 años
She is 7 years old.
y espera ver a su madre y abrazarla
And she hopes to see her mother and hug her very soon.
muy pronto.
Very soon.
Ruego a ustedes, imploro, perdón, suplico, comprensión.
I beg for your help, forgiveness, and understanding.
Hija querida, recuerda siempre
My beloved daughter, always remember
que nunca te olvidaremos.
that we will never,
A Yailin,
never forget Jaylene,
mi amada nietecita,
my beloved granddaughter,
que tuve en mis brazos,
who I held
que
in my
todos los días tenía que yo amanecer cogiéndola a mi nieta.
every
Quien
day.
extraño mucho,
We miss you very much,
profundamente,
very deeply.
su imagen está grabada en mi recuerdo.
I carry her image always within my memory.
Yailin es nuestra luz.
Jaylene is the light of our life.
Amaya es nuestra esperanza.
Amaya is our hope.
Te amo, hija,
I love you, my daughter,
hasta el final de mis días.
until the end of my days.
Y aquí estaremos esperando por ti.
And we will be here waiting for you.
Que Dios te dé fuerza, valentía cada día de tu vida.
May God give you strength and courage.
Gracias.
Every day of your life.
Gracias.
Thank you. Thank you.
No, Your Honor, just in quick conclusion, when you're contemplating your decision. She was obviously struggling with something that she was unaware of. Doctors weren't aware of, her family was unaware of. It's not, again, not a justification for what she did. But when she finally returned home and called 911, that fear, and also what wasn't mentioned earlier in the recording, she was told to perform CPR and she tried to bring her daughter back, or tried to do whatever she could. And I asked her too, recently, hey, if that would have been successful, had the paramedics or yourself been able to revive Jaylene and she was still here, do you think you belong here in jail? Absolutely, she said. She said, I don't know what I was thinking. I don't know. I can't put myself back into that state of mind I was in. She hates herself for it. She thinks of her daughter, and I actually will let her speak now. Thank you.
Ms. Candelaria, you want to stand up and address the court?
Your Honor, good morning. Sorry. Hay mucho dolor que tengo con respecto a la pérdida de mi bebé Yailin.
There's so much pain that I have in regards to the loss of my baby, Jaylene.
Estoy muy dolida por todo lo que pasó.
I'm extremely hurt about everything that happened.
No estoy tratando de justificar mis actos,
I am not trying to justify my actions,
pero nadie sabe cuánto yo estaba sufriendo.
but nobody knew how much I was suffering
Y por lo que estaba pasando.
and what I was going through.
Todos los días le pido perdón a Dios y a mi hija, Yailin.
Every day I ask forgiveness from God and from my daughter, Jaylene.
Soy una persona creyente de Dios
I'm a person who believes in God.
y reconozco hoy que todos y todas, muchas ocasiones, somos tentados por el enemigo.
And I recognize today that all of us are sometimes subject to the enemy.
Dios y mi hija me han perdonado.
God and my daughter have forgiven me.
Quisiera pedir perdón también a mi hija Amaya
I would also like to ask Amaya, my daughter Amaya, for forgiveness.
y a mis padres.
And I'd like to ask my parents for forgiveness.
No se imaginan cuánto yo era unida a mi hija Yailin y Amaya.
One can't imagine how close I was to my daughters, Jaylene and Amaya,
Y cuánto nos amábamos todas.
and how much we all loved one another.
Extraño mucho a mis hijas.
I miss my daughters very much.
Hoy nada puede devolverme a Amaya, a Yailin, perdón.
Now, I know that nothing can bring Jaylene back.
Y no pasa un día que no deje de pensar en ella.
And not a day goes by when I do not think of her.
Le pido a Dios que algún día pueda volverla a ver
I pray to God that one day I will see her again.
y poder retornar junto con Amaya, que es nuestra única esperanza el día de hoy.
And I pray also that one day I can be reunited with Amaya, who is our only hope right now.
Thank you, Susan. Your honor.
Thank you, Your Honor.
Anything else, Mr. Smith?
Anything else, Your Honor?
Ms. Candelaria, you might as well stand up. This court has to impose a sentence here today. And the first thing a judge has to do is look at the purposes and principles of sentencing. That is, the sentence must comply with these purposes and principles under our revised code 292911A. The overriding purposes is to punish the offender and protect the public from future crime by this offender and others, using the minimum sanctions that the court determines accomplishes this purpose without imposing an unnecessary burden on state or local government resources. I always have to consider the need for incapacitation, deterrence, rehabilitation, and restitution. The sentence should be commensurate with and not demeaning to the seriousness of the offender's conduct, its impact on the victims, and consistent with sentences for similar crimes by similar offenders. Ms. Candelaria, I am not sentencing you today based on your race, your ethnicity, your gender, or your religion. Do you understand?
Yes.
I sat here, listened, and I'm looking in the back of this courtroom, and I think of Dr. Mooney's statements to me, Sergeant Detective Teresa Gomez, and Detective Powell, and these three experienced, very talented, hardworking individuals all called this one of the most horrific cases they've ever seen. I look in the back of this courtroom and I see law enforcement, I see individuals who have worked on this case, who are here because it's also affected them and how horrific this crime is. It stunned people across this world because it defies one of the basic human responsibilities. The bond between a mother and a child is one of the most purest and most sacred bonds between human beings. It's a relationship built on love, trust, and unwavering protection. Yet, in a shocking and betrayal of this fundamental trust, you committed the ultimate act of betrayal, leaving your baby terrified, alone, unprotected, to suffer what I heard was the most gruesome death imaginable, with no food, no water, no protection, and lying in her own feces. Ms. Candelaria,
You know the responsibility of parenting. You have a child already. You raised another child. And I've witnessed here before me your parents who showed you love and respect and education. And they came here to help you, to advocate for you, more than what you've done for your own child. The evidence that I've witnessed here before this court shows that this time you simply chose not to be here because you wanted to have fun. You decided you needed a vacation. And what followed was absolute depravity. You left your baby, Jalen, trapped in a pack and play without food and water for 10 days. This wasn't simply an oversight. You could have saved Jalen's life many times. You could have found someone to watch her while you were gone. You could have taken her with you while you were in Detroit or Puerto Rico. You could have called someone in Cleveland and told them that Jalen needed help. Dr. Mooney indicated that rigor mortis was found when they found her, which means she didn't die that long before you came home. Think about that. Despite all of her suffering, that little baby persevered, waiting for someone to save her. And you could have done that with a simple phone call. Instead, I see photos of you on a beach while your child was eating her own feces in an attempt to survive. Photos mean something. And I'm well aware of mental health, but didn't look like you were too concerned about your child. As if that wasn't bad enough, you extended your stay in Detroit without regard to Jalen, alone, in pain, clawing her face in distress from the exhibits I just looked at, trapped in a tiny prison that you left her in. When you got home, you knew enough to start lying. You concocted story after story, trying to hide what you did. You even put pants on her, but you couldn't hide the absolute horror and filth that she spent the last days of her life in. You still didn't get it. I hear this morning that you went out and managed to go out with someone that you were with, and he was too upset to eat, but you weren't. And then I hear that you're in jail and you're telling people, I can't wait to get home. I look at remorse. I hear, except for the acceptance of responsibility, no remorse. As a court, I have to remember Jalen, where you did not. Just as you didn't let Jalen out of her confinement until she died, so too, you should spend the rest of your life in a cell without freedom. The only difference will be that prison will at least feed you and give you liquids that you deny her. Based on all these factors, and based on all the things I've looked at, and I'm marking this as State's Exhibit 1 for the court reporter. On count 1, aggravated murder, I'm going to sentence you to life in prison without the possibility of parole. On count 5, I'm going to sentence you to 8 years to run concurrent to count 1. I'm going to tell you, Crystal, this is probably one of the most difficult, horrific cases to listen to hear, and to see. And I can tell you that I appreciate the fact that the state of Ohio presented this matter in a professional way, and the defense has acted in a professional way. You have a right to appeal my sentence. Do you have the money or means to hire a lawyer at this time?
No.
All right. I'll appoint a lawyer to represent her. And on the endangering children, because of the Reagan-Tokes thing, it would be 8 to 12 years. That would be concurrent with the aggravated murder, life without parole. Is there anything else, Mr. Smith, on behalf of the defense?
Nothing further.
Anything on behalf of the?
No, Your Honor, thank you.
All right, thank you. Court's adjourned.
Right.
All right, close up cameraman. Gee whiz. Get my cursor back over here. The her defense attorney, he seemed a little lighter after that sentence. Did you notice? He didn't seem so heavy. I don't think he did it. She was a job. He had to do it. And that's it. I honestly think that. They're very classy of him to go over to the prosecutor because I think he saw how horrific this was just as much as they did. Because when he was talking and saying what he had to say about her, I don't think it was easy. He seemed very angry. Yeah, it was intense. The crying that came through on that Ring doorbell gave me chills to listen to that poor thing. I didn't know that that existed. I didn't know she had another child. I don't know. I don't know what's wrong with people. Maybe it's always been wrong with them. I don't get this. And I know I keep covering them because they're just here. I know I don't have to cover them, but I'd rather just, I don't know, bring the light to it. So on that awful note, I'm going to end this stream. It is sad, Gabby. You're correct. She obviously, her parents seem like good people. Call them. They probably would have taken her. Thank you, Felicia, because they're so hard, but I just, they're hard, they're awful, they're haunting, but I just feel the drop. Like, I just feel like we need to cover them. We need to do them. We need to talk about them. Okay, then. I will look up, switch gears. Switching gears. I will look up the name you gave me, Felicia, see what I can find. I've got a note about it for April 3rd. I have no idea what we're going to do Monday. So if you see anything, drop me an email because I'll be looking. I will be looking. That's true. That's true. And if you see anything and you want to drop me an email, it's on my home, my YouTube channel page thing, whatever. Thanks, Adair. Thanks for being here. Thanks all of you for being here. As I always tell you, every Friday, have a good weekend. Do something fun. Be careful. Be safe. I want you all here next week because I don't want to have to bail any of you out. So I plan on having a very quiet weekend, which means I won't. Toodaloo to you too, Gabby. Dang it. All right, you guys. Thank you so much for hanging out again. I don't have anything else. I'm just going to end it. The stream right here. So, all right. See you guys 10:30 a.m. Eastern Time Monday. Bye.